Frank and Elaine Sommerville. Frank and his team are our resource for legal issues, and as Frank states, and you still put that on your email signature? If you didn't pay for it, this is just advice. So
No, it's not advice.
it's not advice.
Unless you pay for it.
It's not advice unless you pay for it. I got that wrong. Okay, yes. Thanks. I want to make sure I legally say that correctly.
Right.
So Frank, to say they're experts is in religious organization, tax, and law is an understatement. Frank was inducted into the National Association of Church Business Administrators Hall of Fame, and so was Elaine as well. Frank is a shareholder in WKPZ out of Dallas and Houston, Texas. Elaine is sole shareholder of Somerville and Associates that works with tax and financial advice and for over 300 religious organizations. So it is a treat. They are going to be great, and they were great yesterday. I got to see them in action yesterday, and you're going to have a great time. Take lots of notes, and they love questions, and they have prizes for questions. So please welcome Frank and Elaine Sommerville.
Thank you. Wow.
Who wants the power?
Give it to him.
Wow. I get the power today. Welcome, everyone. How many of you have not heard us before? Oh, look at that. Oh, my. It's an honor to be here. It is. I've been doing church work all my life. My dad was a pastor. Granddad was a pastor. I practiced as an accountant for a while and then became a lawyer, and been working in this area for nearly 40 years between the CPA time and the law time. Elaine, she doesn't look old enough, but she has got 30 years of experience as a CPA representing nonprofit organizations, religious ones. She's been through a lot of the fires that have happened in this area as well. She also is AICPA, the professional organization for CPAs, has her as the instructor for their advanced nonprofit tax. So other CPAs honor and respect her and her advice.
Thank you. So we are here. Ooh, this is really loud. So we're here to spend the next few hours with you. Travis is right. We do like questions. We're going to cover a lot of material. We come a little bit with a warning. We're not your typical presenters. Number one, this whole morning is not scripted for you, which means we have no idea really what's going to come out of our mouths for most of it. The other thing is that Frank and I do approach things a little differently, being from tax or from the CPA and the legal side, and so we don't always 100% agree with each other all the time. So some of you who have heard us speak before, you're back to hear us speak just because you're just waiting to see when we don't agree with each other. We do have people who come hear us just to get in on the disagreements. But what we're going to do today is we are going to go through two things. We have two presentations, really. Maybe a little bit kind of like three, but one of them is a tax and legal update, and all we do is go through cases, rulings. These are not necessarily about churches, but they all deal with nonprofit tax and legal issues that you face. And so we take those and we kind of then try to apply them to your situations. We do take a lot of questions along the way. Sometimes we get to look at you and say, we don't know, or that's got way too many factors for us to stand up here and give you an answer for.
What we try to do is we go through and select those that we think are most relevant and interesting for you. We try to make this semi-entertaining as we go through today. It is, all of these topics are relevant to you as a church administrators. We use them to introduce the topic, and that's where the questions come in. So that's why we don't always know what we're going to say. We're just going to go with the flow. If we get too many questions, we may have to cut it off so that we can cover all of the topics. So we want to remain respectful of your time so that we finish up at the right time. We'll do this update first, And then I will do a session just on HR updates that are relevant to churches. And then Elaine will wrap it up with a compensation session on how to set compensation correctly and how to defend it and that sort of thing to wrap up the day.
Right. Okay, are you ready?
I'm ready.
Okay, let's go. Are y'all ready? Okay.
Affordable Care Act.
Okay, so the first thing is we've put the ACA up front, but just as a question, how many employers do we have in here? You represent an employer that is has more than 50 full-time equivalents. We're just trying to gauge interest, and that's more than yesterday.
Yeah.
Anyway, so my caveat to this is we're not going to let the ACA hijack the whole day. So that's to say we're going to cover a really brief snippet of it here, and then we have another snippet to cover later on.
Yeah, the Affordable Care Act, in June, when I was at an IRS meeting with IRS officials, there's a committee that advises them, and they announced that they were going to be conducting hundreds of church examinations between June and the end of the year. We've already handled 3 of them for ACA compliance.
And these are all on our 50 full-time equivalent and greater employers,
All
right?
of these have been 50 full-time equivalent employers. You know, you're required to file a 1094-C with the IRS reflecting the health insurance and all of your employees. And the insurance company prepares those for you. So that's the easy part. The problem I'll give you the 3 instances we've had so far. The biggest one was converting an employee from part-time to full-time. Because you don't report your part-time employees to the insurance carrier because they're not eligible for coverage, the insurance carrier left those months blank, and the IRS automatically assumed that they were eligible and did not enroll because there's a code that you have to put in those boxes that says part-time not eligible. And since those were blank, the church got an assessment of over $200,000. These penalties for the Affordable Care Act are outrageous. They are very, very expensive. And so that one we were able to go ahead and show the IRS that this person was part-time and correct. We amended the 1094-C and got that one go. Another one we had was just the wrong Social Security number. And again, that's one of those things you don't think about. You put it in one time in our systems and it carries over, but somewhere along the way, it changed 1 digit. Now, the third one is the one that I need to caution you about. And this one was more legitimate, and it, again, was over $250,000 penalty. They had an employee who opted out of the group health insurance because they were covered through their spouse. Fairly common. All of you probably have at least one or more of those, right? Where the mess up came is that employee spouse was later laid off from her job and lost the group health insurance. What the Affordable Care Act requires is that employee has to come back to you at that point and you re-enroll them in the group health insurance. In this case, the employee went to the exchange, purchased a policy for his family, and claimed the credit. Okay? Because it was available and because he claimed the credit and he was not re-enrolled into the group health insurance, it was $3,000 per employee per month. So do the math. Those of you, and it's less 30 employees, so they take 30 off. So if you had 100 employees, that would be 70 employees times $3,000, $210,000 for 1 month. Okay? For one employee making the mistake. Okay? So here's the problem. You're letting them opt out because they have group health insurance somewhere else and they're providing you that proof. but you're not informing them that if they lose that coverage for any reason, they have to come back to you. And your plan has to allow them to re-enroll at that point. And so the employee doesn't know, they're doing it out of ignorance, because he just looked at it and said, okay, well, the church insurance is way too expensive. I can go to the exchange, I can get a lot less expensive, and I can get the credit back. And that was the problem for the church. So I have an opt-out form that I have drafted for your use. If you email me, the email's on the handout, I can send that to you to reflect and notice to your employees that you tried to tell them they can't go elsewhere if they lose their group health insurance.
The next one has to do, we have a couple of things in here going on with schools. How many of you either are here representing a school or you have, your religious organization has a school with it? How many? We have a lot of schools with us today. Great. Well, a couple of things. How many of you, your school is separately incorporated or it's a part of your church operations? Separately incorporated. Just a few. Part of church operations. Most of you. Okay. So this ruling kind of goes to you. It has to do with the Mayo Clinic, which is a health clinic, and an educational institution. And the IRS had decided that since the Mayo Clinic was not predominantly, or their primary purpose wasn't to be an educational institution, then it could not consider itself an educational institution for purposes of various benefits that are allowed to educational organizations. And so Mayo Clinic took them to court and actually got the court to disagree with the IRS and to tell the IRS that their regulation that they wrote, saying that it had to be the primary operations, was beyond the scope of the congressional intent. And so this is really good for churches that have educational activities also, because it clarifies to everybody that that part of our operations that are educational, we can consider an educational institution. And there are just various parts of tax law that makes a difference too. The second issue we have for, why don't you see, let's skip those and pull up one more. Let's look at the third point there, and we'll do both our school issues together. The second issue is really relevant to all of you. How many of you are aware that as an educational institution, you are required to publish your non-discrimination policy every year in a newspaper or a radio advertisement? How many of you are aware that every year you're required to file a Form 5578 with the IRS telling them that you've published your radio
If you don't file a 990.
television, or your radio or newspaper, if you don't file a 990? Okay, well, let's start with the rule, the basic rule. All private schools are required to operate on a non-discriminatory basis. You are only allowed to discriminate on the basis of religion. In other words, you could restrict your private school to your faith. That non-discrimination policy, which applies to your students and your administration and your staffing, is required until 2019, was required by 1975 ruling that it is published once a year in a common newspaper to your vicinity. And the ruling tells you exactly how big the font is and exactly what it's supposed to say. It's also supposed to be in your handbooks, your employer handbooks, your student handbooks.
What's that? This, where is it in the handout?
It's not in the handout. We added this because this is pretty recent. So this particular point is not in the handout. It was added after it was sent in. And so the point of the non-discrimination policy is that it's part of you being able to be an exempt school. So then what the IRS does with all exempt schools that file a 990, you have to certify that you do this. If you don't file a 990 every year, your school's required to file a Form 5578, or your church is, if it's hosting the school, a Form 5578 with the IRS that tells them you're complying with all the non-discrimination requirements. Until 2019, we had to do this through a newspaper or a radio ad. And you're all looking at me like, newspaper or radio, right?
And you still subscribe to newspapers?
So yeah, I would like talk to clients. They're going, we don't have a newspaper that serves our area. Well, in 2019, the IRS has decided to come into the age of technology. And now you are allowed to publish the non-discrimination statement on your website. It must be on your home page.
The landing page.
Okay? And so it must be a certain font. It must be to draw attention to itself. There are still the requirements to be met. And then it still is supposed to be in your handbooks and other places too. But they are allowing you to not have to use a newspaper anymore. We do get to go ahead and use our website. If you need information on this whole subject, because you're looking at me going, we don't do any of that, please feel free to contact me. And I can give you that information. I can provide you with the original ruling and with the updated ruling so that you can come into compliance. I stress this because this is grounds for revocation of your tax exempt status.
And not just of the school, the entire church.
The entire church.
Separately
We have
incorporated.
had a church in Houston was contacted because they did not file their Form 5578. And the IRS agent asked the church, why should I not revoke your tax exempt status? You did not comply with this. So this is something that if you don't think your educational institution or that arm of you is doing it, you desperately do need to come into compliance in this area. Okay, now we can back up to Roe versus U.S. and U.S. versus Bible study time.
Right. Both of these deal with something called the Church Audit Act, which was enacted in 1976, and that restricts the IRS from just auditing churches on a whim because there was concern for religious discrimination by IRS. And in Roe, we had probably the senior pastor of a church who was being investigated by the IRS for tax evasion. I know none of your pastors would ever do anything like that, but this pastor did, and so the IRS subpoenaed, it's called summons is the correct terminology for IRS, but it's a subpoena for all of the church records. And the church says, wait, we're protected by the Church Audit Act, we don't have to produce all this stuff. And the court said, no, this is not an examination of the church. This is an examination of the employee, the pastor, and we get to look through the church books to see if there's anything in there that was unreported and is taxable income. And so that's what that one is important. So if you get an IRS summons or subpoena, you need to hire legal counsel to help you respond to that, because not all of them are going to fit in that particular category. The second one is there's under the original law, the regulations said that the IRS audits of churches had to be approved by a high-level Treasury official, and the regulations said that was the regional commissioner of Internal Revenue. Well, we don't have regional commissioners. We haven't had them since 1998. And so the IRS is trying to find the level that is appropriate. In this case, it was the Director of Examinations for exempt organizations. That wasn't high enough. The exam notices that I am getting now for these ACA things are signed by the Commissioner of EO and TG, which is exempt organizations and governmental entities. And so that is roughly equivalent to a regional commissioner. There are only 4 of those, and there were 7 regional commissioners. So I think that they've fixed that problem. And so far, I have not had to challenge whether or not that person has the high ranking, because we've been able to resolve the issue with IRS. But that's why that's important for you to know.
All right, this is a kind of a very, very interesting ruling that's come down that's really going to hit close to home for a lot of people. This is the one time today we're going to have the fun of talking about foreign activities, at which point, Frank will tell you you're going to jail at some point within the next 5 minutes, okay? It's okay, you'll get used to it. So this was a mission-sending organization. Everybody knows what a mission-sending organization is, right? They have missionaries that come and sign up with them, and then the missionary will go to Africa. All the support will come through the mission-sending organization, and then the mission-sending organization will support the missionary in Africa. That's how they generally work. This one did a couple of more things. They actually set up donor-advised funds. Now, donor-advised fund is kind of this unique little creature we have in the tax world of tax exempts that says, I as a donor could like deposit $50,000 with an organization, and then within a framework, I would come in at various times and tell them what to do with that money. So I would say, go send it to Missionary Bob, or today I want to send it to Missionary Joe, and I might not do that all in 1 year. That would be a donor advised fund. The other thing they were doing is that they were providing the missionaries with management and accounting services because they were taking all their money in and sending out donor receipts, and they were providing an accounting of how they spent their money, supposedly. And then the other thing they were doing is they were actually operating a retirement plan that the missionaries could participate in. So the IRS has evidently audited this entity. Now you have to understand with private letter rulings, we don't know who this is. We have a lot of connections in this community, but we still don't know who this is. Sometimes we can figure it out from the ruling, but we haven't. So we don't know which organization this is, but they were evidently either audited or they had an application for exempt status, but because they were so operational, they were probably being examined. And so one of the first things the IRS came in and said was, you did not exercise any discretion or judgment or review over the projects the missionaries were doing.
So how many of you send money overseas to a missionary or a NGO, nonprofit organization, or a sister church or something to go like build a school or a church or any of that? How many of you do that directly? How many of you wire that funds over?
Not going through a U.S. org, but just going directly overseas.
Not going through your denominational missions boards or just doing it directly, right? So overseas, outside the United States.
That would include Mexico. It just wouldn't include Puerto Rico, which is a...
It includes Canada. It includes Mexico. Anywhere outside of the United States and territories.
Right.
All right. When you send money outside of the United States, you're responsible for those dollars and how they are spent. And if they end up in the hands of a suspected terrorist, you get to go to prison. Okay?
See how fast he does that? He just slips that right in.
It's nice and simple. It really is that simple. So you're responsible for who they go buy building materials from. You're responsible for who they hire to do the bricklaying. You're responsible for every dollar because it's got your name on it.
Well, but more common than that,
More?
and really to this ruling, which did not specifically cite that law, is that you are also responsible to make sure they spend all that money on an exempt purpose. Okay, you don't get to take their word for it that they're going to do something. And so it's a twofold test. So what the IRS really was pointing out in this one is that they were sending money over. They didn't review a project to figure out if it was within exempt purposes. They didn't review if the project was getting done. They didn't ask for a grant inquiry. They didn't ask for anything that really, basically the missionary called them up and said, we need $5,000, and they sent it. Okay, you can go on with your scary stuff now.
Well, now, what we recommend is that you have a written grant agreement with the foreign organization and says, we agree we're going to spend these funds on this particular purpose. We're agreeing that we're going to account for those funds through receipts and accounting back to you, and that we're open to you auditing or verifying that we're actually complying with the agreement, which you're required to do to prove that you did it for exempt purposes. And now, you're talking to the daughter of a missionary over here, okay? And she knows and has been in parts of the world where receipts are scarce. Or you can buy all the receipts you want off of the street vendor for any amount you want. So, you know, in my ideal world, I want receipts, I want canceled checks, I want invoices, but
And in his ideal world, he wants you to screen that great little street vendor you bought the mangoes off of someplace. And that's not happening. So in a less than ideal world, with Mr. Somerville's perfection standards over here, is our realistic working world.
really,
Yes. So, number one, I would tell you that there are a lot more receipts in foreign countries than people want to say they are. We have a cultural response back to Americans. It's like, we don't do that over here. We've been in some underdeveloped countries, and that's true. I've been in places, I was in Vietnam this year, I was in places there would be no receipts. I wouldn't, off a street vendor. I was also in places in Vietnam there were plenty of receipts, okay? But it is taking, even if we do a short-term mission trip or we're sending money over, when our dollars go to a foreign soil, we're required to know what happened to them. And that means that somebody has to do an accounting back either through a journal with dated entries and amounts, with receipts where you can get them. And so, in a way, while we didn't even mention this yesterday, and I want you to hear that, when you send $10,000 on a short-term foreign mission trip, the guy who brings it back better bring back all the receipts and accounting of how they spent the money.
well,
And-
she even brought back a receipt for the necklace you bought in Vietnam.
Well, that was easy. So, but it has to do with changing our mentality away from this. Oh, we can't get that over there. Well, everybody can keep some sort of track of expenses. I also know that culturally, people don't like to account for things. I had a client who supported an orphanage in Ghana and was very successful in taking children out of trafficked situations. They could not get the Ghana national to get on board with the reporting requirements, so they closed the orphanage down and went and built their own someplace else. And really, that's what you have to get to a lot of times when you have foreign nationals who refuse to cooperate. They have to know that you're not sending the money if they don't comply with the rules. And Frank is right. We have had one conviction that we're aware of for an organization that funneled money into Syria against U.S. law and tried to do it, kind of subvert it through a Swiss organization, and it still ended up in a sanctioned country, and that person was convicted for that. There are some really serious penalties out there. We had a lady with us yesterday who, unfortunately, their organization is shipping food into Venezuela. Venezuela is a sanctioned country right now. You are not allowed to do anything like that. So we have sanctioned countries that the U.S. tells us what we can and can't not do in those countries. Cuba is one of the ones that's been sanctioned for years. And then we have sanctioned individuals and organizations, and those are the ones on the specially designated nationals listings that we have through the U.S. Treasury and U.S. Secretary of State's office. So there are some real reasons why you want to move to your grant inquiries and formalize this into grant agreements that also will define when you stop sending money. So.
And you want all of the funding sources for that project, because some of our missionaries are less than honorable. When we were auditing a few years ago, a particular church was sending $1,000 a month for this missionary to labor away in Africa. That was great, and that's laudable, except that missionary told them that was their only source of support. And $1,000 does go a long ways in certain countries in Africa. But when we found out later, he had 20 churches sending him $1,000 a month. And for $20,000 a month in this particular African country, he had a 6,000 square foot house. He had maids, he had gardeners, he had drivers, he had a Mercedes. All of these things that, are anti what we would consider good stewardship. Okay? So that's why you want the budget for the entire project, and you want to verify that you're the only source of that project if that's what's being represented to you. If you're responsible for $5,000 of a $25,000 project, that's okay, but you want accounting for all of the project, and you want all the sources revealed so that you can be a good steward, and because if you do what they were doing, that's not fulfilling your exempt purposes, and that could cost you your tax exempt status.
So not only regulatory are we increasing in this area, which kind of puts a damper on the whole thing for the religious organizations, but we are also seeing some kickback on banks who are dealing with greater bank regulations and about how we send money overseas. So we have had clients actually be contacted and say, we're going to shut down all your accounts because we don't like where you're sending, how you're wiring money overseas.
Yeah, I just had that yesterday. I responded to an email where church getting an inquiry from their bank saying, we need the licenses. You can do things like in Cuba or in Venezuela with the proper licenses, a license issued by the Office of Foreign Asset Control, or OFAC. And so they were wanting copies of the license. The church did a short-term mission trip in May to Cuba, and they wanted to verify that they had the appropriate licenses. So this is going on all the time, but you got to pay attention, because if you don't have that OFAC license, the bank's going to shut down your bank accounts, they're going to call your loans, and then they're reporting you to the feds. Yes, ma'am.
Two questions on the Venezuela thing. We did send money to Venezuela to an organization that bought food. Is that okay?
No,
Okay, so we're not supposed to do that at all.
not without a license. OFAC, the Department of Treasury, OFAC, and there are licenses available. Right now for Venezuela, it's about a 6-month wait to get the license back. So if you're going to send money, the other part is you can send it to a U.S. entity that already has the license, and then they can send it to Venezuela. And so part of it is, there are licenses. We've already renewed 2 licenses for Venezuela this year because the licenses went in, they became a sanctioned country in February the 24th of 2019. And we got a short-term license through July, and now we have another license through January 31st of 2020. So you can do the licenses. Remember that it's going to take some processing time. And they have to, one of the legitimate reasons are food and medicine. Those are really the only 2 things that you can get a license for at the moment for Venezuela. So you have to be very, very careful, because if you send it, if a church put in DHL a box of food and it went to a Venezuelan address, you're toast. Okay? Yeah. Yes, ma'am.
I work for a denominational office, and we sponsor new church startups. I want to know about our liability when I've told a new church startup they cannot send money to Egypt. How we can protect us, because I've already told them don't do it, but I don't know what they're doing that they're not telling me.
Right. So the church, a local church there, she's with a denominational office. The local church may or may not be doing what you ask them to do. Egypt is not a closed country at the moment.
Is your startup still under your corporate entity? That's what I thought she was worried about.
That's the problem.
So then
Yeah.
you do have the ultimate responsibility with basically asking them to, that's reviewing their own accounting and going through that and making sure they're not doing any foreign activities you've told them not to do. And so when you get, this is where the mean CPA and attorney come in. That's when you get to look at them and go, no, you don't understand. We're shutting you down if you don't stop.
Or we're removing you
We're
from
not
leadership.
risking all of this because you want to try to play cutesy with the rules in this area. And this is why you use U.S. mission sending organizations
We're huge fans of the denominational.
And your
mission
missionaries are going to
boards.
look at you and go, we don't want to use one of those. They take 15% of what you send through there. There's a reason they take 15% of what they send through there, because they have to do all of this, right?
And they are, the larger ones are.
And the larger ones, the more established ones are recognizing all of this and are working for it. They're earning their money. And so it doesn't do you, the church, or the missionary any good to let them get outside of that system and let you take that responsibility. Yes?
So say we have a mission trip to Mexico.
Okay.
And our school goes there every year, and they go to an orphanage over there, and we say, hey, they collected $5,000, and we're gonna donate that to the orphanage.
So you want to donate money to the orphanage, what you need to do,
But it's in Mexico.
it's in Mexico, so you need to really go in there proactively. You need to screen all the leaders of that orphanage through the suspected and known terrorist websites before you go. You need to document whether or not they're a Mexican NGO and in good standing. So you just need to take some steps, and then you need to ask them, where are your financials? How do you spend your money every year? And your boots on the ground organizations are great, because that is part of your expenditure responsibility too, because you see it and you know it. And so all of that gets documented ahead of time.
And I would try to document specifically how they're going to spend the $5,000. Even if it's just operating expenses, salaries, document that they spend at least $5,000 on salaries, so that you, again, show that this money is being spent within your exempt purposes. Yes?
We send $200 a month to a church in the Philippines. Do we need to have protection for that?
Yes.
So what do we need to do to, we
What-
send it directly to this church? in the
What I would do is have a grant agreement with that church in the Philippines, saying, we're going to send you $200 and you're going to provide us documentation of how you're spending this $200 on church purposes. And you're going to, by the way, you're going to send that documentation for that $200 before we send the next check. Okay? Yeah.
Wait.
Yeah, no, that's the way you do it.
No. No. Let's play a little materiality game here. I don't think they have to document the $200 immediately. I think they can do a grant agreement. They can show you what their budget is for the year. They can continue to send you at certain points. If this is regular, they would send you some sort of financial statement update. And then you're gaining assurances that you're $200. Now, then all of a sudden they say, we need X, and you decide you want to spend $1,000 or $5,000. That's a separate grant agreement. So you're doing a grant agreement for the $200 a month. I don't necessarily believe they have to send you documentation for $200 every single month. But there are, if you do a one-year agreement, there are places you do check up on it.
Yeah, the more background check, and by the way, we have, for that situation, we have something that's called an equivalency opinion. And the IRS agrees that this works if you bring it to a U.S. CPA or attorney, and we review that foreign entity's governing documents and their financials, and we say, okay, we're rendering a legal opinion that this organization would be a 501c3 if it was located in the United States, but it's located somewhere else.
And that's a great system if you have a sister organization someplace that you know you're going to regularly support. Those equivalency opinions are good for 2 years. And so at that point, the expenditure responsibility is relieved from you, and you can just go ahead and provide them with support. I'd still do grant agreements because you still need to know what your money's going to be spent for. But you don't have this expenditure responsibility back. And it is a great tool to use when you have an organization you're supporting regularly. We're going to take 2 more questions on foreign activities. We're going to take this one right here.
I have 2 quick ones. One is, so you're saying if we use the donations to go through a United States 501c3, we're clear we don't need to do any more research because the burden's on them?
Correct.
Correct.
And what if we do fundraisers and say, this is a great project, everybody write checks personally to then is the organization cleared of that, or
Who are we telling everybody to write their checks to?
a sister church?
A sister church in another country? No, that is not going to work. Because you're using your resources to do fundraising for them. You have the responsibility to make sure that that is a viable organization, and all the reporting and the screening is still going to be on you.
And the other problem that you have, which we don't talk about today, is restricted gifts. If you fundraise for one purpose and you spend it for something else, or you can't prove that it was spent for that purpose, that's called fraud. And we
We're on a
had
roll now. We got going to jail for foreign activities and fraud all in like 15 minutes.
we had Gospel for Asia was a $100 million a year foreign mission sending organization, charitable organization operating in India. They got a class action seeking $5 billion of damages because they could not trace in their catalog. They would say, for $50, buy a goat for a farmer in India. They could not trace that $50 from that donor to the receipt showing the purchase of a goat in Nepal or India. They settled it earlier this year for $38 million, okay? Because they couldn't trace their restricted gifts. So be very, very careful. It sounds great. You know, go buy a blanket for someone in the Alps or the Andes. You know, that sounds great. But now you have the responsibility to go produce a receipt for a blanket that ended up protecting one of those individuals. Okay?
One more question.
Do you have a suggestion for a grant agreement online, you guys?
Email me. I'll send you a sample one. Yes, that's no problem. We're happy to do that.
Okay, let's go on. We are available. We
breaks.
do ask that you give us a few minutes at breaks. But we're also available after we finish here today for a few minutes. We have about maybe 15 or 20 minutes afterwards.
A little longer.
A little 30 before we have to head for the airport. And so, yes, so if we don't get to your question while we're in the zone here, we can help it afterwards. What's the next one? You have the power. You lost the power. Man.
You want to talk about the non-qualified retirement plan? First of all, I was reading this morning in Christianity Today a survey that said that 62% of our ministers don't have a retirement plan, qualified or non-qualified. And that's just horrendous to me because we're dealing constantly. I dealt with one of the questions yesterday. We have a pastor, we've never put a retirement plan together for him. He's been here for 40 years. We want to give him the house the parsonage that they've owned and lived in for 40 years as a retirement gift, and that isn't going to work. So non-qualified retirement plans like Rabbi Trust and stuff like that are very, very, very technical. And I can tell you, I've reviewed 2 so far this year, and 2 flunked because one of them flunked because their plan documents were wrong. The second one flunked because the church didn't operate it properly. And so it's easier to mess up on a non-qualified deferred compensation plan than it is to do it right. In fact, I quit doing them in 2006 because I couldn't find churches that would operate them properly, even though I could draft the documents properly.
All right, well, let's go on to our next topic, and that has to do with a couple of tests you have to pass in order to be a 501c3. I will tell you that, yes, as a church, you are a 501c3 organization. This is what gives you your exemption, whether you've had to ask the IRS for it directly or not. You are still a C3 organization. And as a C3 organization, there are 2 tests you have to pass. And the first one we're going to briefly talk about is the operational test. And that is very easy. You're all here, so you're all with operating organizations, operating for your exempt statuses. So I only put this in here because sometimes my churches will set up organizations like foundations or, we want to do a community project with 4 other churches, or, we have this great idea and somebody set up an exempt organization and then they don't do anything with it. So this is to tell you that the IRS is ruling that organizations that are dormant with no plans for activities, and they're dormant for as little as a year to 2 years, the IRS is revoking their tax exempt status. So don't trust any of those organizations if they've been sitting on the shelf for too long. Just go ahead and shut them down and get rid of them. The second test you have to pass is one that most of you don't think about a whole lot. It's called your organizational test. And this is going to go directly to your organizing documents and your governing documents. And so there are just specific ways we have to pass this particular test. And the reason most of the time when we find that this test is a failure is because you haven't looked at your organizing documents in, I don't know, how long has it been since you dusted off that file or someone asked a question about it? And so we deal a lot with, I've been in denominational churches. I was in a Baptist church one time and I read their organizing documents and I was like, so you have a board of directors? And they're like, no. And I said, well, that's what your organizing document says. Or I was in a Methodist church one time and I said, you don't have the mandatory dissolution clause, and I rattled off a couple of more, in your articles of incorporation, so you do realize you're not tax exempt anymore. And they're like, oh no, we're a part of the denominational ruling. I said, I don't care. Because that denominational ruling does not save you if you don't pass all the tests. So every church that's a part of a denominational ruling, in and of itself, you have to pass all the exemption tests. So Frank's now going to tell you the legal side of what happens beyond just tax exemption. Some of the other things that happen when you're organizing documents don't meet the test.
All right, let's set up the hierarchy here. The California Corporations Code is the supreme authority. That's the Bible, okay? Most of you are organized or should be organized as a nonprofit, religious nonprofit corporation, which is part of the California Corporations Code. Everything in your articles of incorporation have to be authorized by the California Corporations Code. Everything in your bylaws has to be authorized by your articles of incorporation and the California Corporations Code. Clear? That we have this hierarchy. So lots of churches will amend their bylaws but never even look at the articles of incorporation. We just finished a project for one of our clients, large mega church. They went to go borrow $7 million to build a new building on their plant. And the bank comes back to them and says, we can't lend you money. And they said, why not? And they said, because you don't exist. What had happened is their articles of incorporation, they were formed in 1946, and their articles of incorporation said, the corporation shall expire in 50 years. So in 1996, they no longer existed. Now, under that state's law, this was Texas, it said that if you have one of those 50-year provisions, it's automatically extended. But the lender was unwilling to lend money, and we found all kinds of problems with their articles of incorporation because, believe it or not, the law has changed since 1946. And I served on the Texas committees that rewrote the Nonprofit Corporation Act in 94 and 2006, so I know at least those two revisions, and you have revisions in the California Corporations Code every time the legislature meets. And so what we had to do is we had to redo their articles of incorporation. We also had to redo their bylaws because those also didn't comply. So you have IRS compliance, which has dissolution clause, purpose clause, prohibitions clause. There's about 7 things that the IRS requires, but those are not part of what the Secretary of State for California requires for you to form a nonprofit corporation. So you can file articles of incorporation that will be accepted by the California Secretary of State, but you're not tax exempt.
So you have to blend them together, all the requirements.
If you take the IRS's forms off of their website, they don't comply with the California Corporations Code, and those are going to get rejected.
And this is why you don't let your real estate attorney draft and look at your governing documents.
Yes, sir.
How can we get a copy of something that covers both bases when I review these documents?
The problem you have, there isn't a single source. The California Attorney General has a really good guide on nonprofit corporations and talks about the tax issues. It doesn't come out of the Secretary of State's office, but it comes out of the AG's, because you have a strong nonprofit division of the California Attorney General's office. They have about an 80-page booklet that will really help you. All of it applies to churches, even if they don't address church specifically in there. And if you just go over to the California Attorney General at their website and search for nonprofit guide, that'll pop up for you. That's the closest I can get to getting both of those together. Really, what you want is an attorney who does nonprofit corporate work all the time, because those individuals are very tuned in to the tax rules and the state law rules to making sure that you are compliant. There are things, the other thing that you need to think about is if you don't mention something in your bylaws or articles of incorporation, the California Corporation Code provides that term. And you may or may not like it. Okay, it may not be what you think it is. So that's why you want a good, thorough bylaws that will reflect everything, the tax law, the corporate law, and what your expectations are. You have to put all of those together. For example, I had a Nebraska judge that voided 14 years of member meetings and all of the elections for 14 years because their articles of incorporation said we'll have one class of members. 14 years before this, they changed their bylaws to allow for multiple classes such as non-resident members and junior members and not inactive members. And all of those classes meant that every election that had taken place since that amendment was void because it wasn't authorized. So that's why I never, ever, ever amend just bylaws. I always review the articles of incorporation first, see what's allowed, and then we have to make those two play nice together. Everything has to be flowing and coordinated between those two documents. It's always a mistake to do one and not the other. Yes?
So do we need to update the articles and bylaws as laws change, or are you just subject to, what was in place, the requirements that were in place when you incorporated?
No, you should be reviewing, I recommend every 3 to 5 years. That you review, annually you need to check with the California Secretary of State and make sure you're still in good standing. But
That's a really good point, because I wanted to make sure we make that point, and that is current registered agent and making sure the right addresses are there.
Yeah, we had a California Corporation registered agent that was on file with the Secretary of State. Unfortunately, was in heaven since '96. And it's a little hard for the California to contact him because the Secretary of State really doesn't have a direct line to heaven. So we have to make sure that those registered agents are current annually, because it could be a former member, it could be someone who has passed away, or your church may have moved. Yes, sir.
Is it still a law or rule or that the board of directors cannot be related?
There's no law that says your board of directors cannot be related that says it that succinctly. It's kind of like a combination of rules that says if your board of directors are all related, then there are certain decisions there's no decision maker for. So for instance, if your board of directors were all related, none of you could make a compensation decision about another family member or one of you that worked for the organization. So it puts you on the side of this presumption that your organization is not going to operate for the good of the public. It will operate for what we call private benefit.
So I will not file the articles of incorporation for you unless a majority of the board members are unrelated. And that's not going to get through IRS standards. And once you start getting relatives involved, it makes it much more complicated to do the conflicts of interest and abide by those rules. So I don't recommend that at all.
We do still see that in the private foundation world, though.
That's still allowed in private foundations,
Well,
not
and-
in
and
private
so-
operating foundations.
And so, you know, I don't want to tell you something's a law and then it still exists out there. There are a lot of other reasons for that. So that was your organizational test. So you always want to make sure the takeaway is let's make sure that we're still organized and we're still in good standing. Let's make sure that we operate the way our organizational documents say we're supposed to, or that we bring everything into alignment. And kind of move away from this idea that, oh, we did that 10 years ago, so it must still be good. So, or we did that 50 years ago, and it must still be okay. It's probably not. So the next group of rulings we want to talk about have to deal with grant programs, or more commonly known in the religious organizations world as benevolence. That's not a term they really use in IRS rulings a whole lot. But the first one does bring out a really great point, and that was we had somebody who tried to set up a tax-exempt organization, and the purpose of the organization was to raise funds to help an individual who had had a debilitating accident and had a lot of needs. And so on the face of things, that sounds great, right? We have somebody who obviously has needs, and we want to help them do that. Well, did the IRS approve this organization? No. Why did the IRS not approve this organization? Private benefit. That's right. That is, everything was just going to be for this one individual. And so this is really the basis on which we work with you and explain to you why your organization cannot go out there and do a big fundraiser for a person or a family and then just write them a check for all the proceeds. So you can't just go say, we're going to raise money for the Smith family who lost their house in the Paradise Fires. And then just whatever money comes in, we're going to write a check to the Smith family, and that's going to be great. We have to do it a different way in order to raise money, because we have to make sure our benevolence plans are operated in a manner that does benefit a greater class than one individual. The next ruling, we look at the same concept and we think, okay, this has got to be better, right? Because this one was going to provide assistance to indigent and disabled firemen. Okay, not just one person. You're thinking, we're on the right roll. This one didn't work. And that's because it didn't operate to benefit enough firemen. So they were all a member of probably one union chapter, one firehouse, and that wasn't enough people. So your benevolence programs are supposed to be geared to operate to help a lot of people with different needs. And so when you have someone with a really unusual need that you do want to help, you need to raise money for your benevolence program and then make decisions out of the funds available. So if you want to help the Smith family, then you can say, we need to help the Smith family, but we can't do that unless you give to our benevolence program so we have enough money to make decisions on how we can help the Smith family and still help everybody else who needs help too. So we never want someone to have the idea that when they give us $1, we're going to give that $1 to the Smith family, because of the private benefit issues and because of the restricted gift issues.
Yeah, right. Now, for benevolence, you need two things. You need documentation on both of these. Are y'all ready? I'm trying to make it simple, okay? One, they have to have a need. A need is not a want. Explain that to your 10-year-old, okay? And that's hard for them to sometimes grasp. We have a 10-year-old granddaughter.
Actually, I think that's the 16-year-old who can't grasp that. I think the 10-year-old can get it.
Okay. Second thing, they have to have an inability to meet that need on their own.
At that point in time.
At that point in time. So, to use the Paradise Fires, those people, their houses were burned up. They may have millions of dollars, but what do they need at the moment? They needed a place to stay. They needed food, shelter, and you could provide that because they had a need and they couldn't meet that need on their own because they couldn't access their records, or the banks were all burned to the ground also. So there are all kinds of issues that come up. But I recommend you use a benevolence application. Email me and I'll send you one.
We don't have a benevolence policy to give to you because benevolence policy should be very carefully drafted with the goals of your organization in mind and your church. You need to really think through who do we want to help? How do we want to help them? How often are we willing to help someone? What do they need to do to receive help? And so think about all those things and work them into your policy, because your benevolence policy is your number one assistance to your staff on how to screen requests. So your benevolence policy tells the staff member who to send somebody to, which person needs, what's going to have to be approved by a committee, what's going to have to be approved by a pastor, what's going to have to be approved by another pastor. The benevolence policy should think through all of that. What would a person have to do? Do they have to meet with a minister if they come in for financial assistance? Do they have to meet with somebody? Do they have to go to Financial Peace before we give them help? You know, can we help them once, and then if they come back again, we're going to make them go to the Financial Peace seminar down the street? And so think through those things, because your benevolence policy really becomes, what I tell people is, it's your basis for being able to just step back and say, I'm so sorry you're going through this, but we can't help you. And your staff member is not making an individual decision at that point. And it just is a protection.
Do
All
any
right.
of your churches have pastor discretionary funds? Oh, my.
Frank, you just had to. Man, now you're going to mess with them. Now you're going to meddle in their affairs.
Yeah, okay. The pastor's discretionary fund is fully taxable to the pastor unless you have a proper policy in place. And that means the pastor has to account for all of those funds, and they have to fit within your benevolence policy. They don't have carte blanche. Those are church funds.
Yeah, so think of your pastor's, that designated account, discretionary fund, as a cash advance that requires an accountable expense reimbursement plan to keep it from not being taxable. Because we kind of work in those words are not foreign to us, but we don't often connect those dots to each other. So if a pastor has access to these funds, then that's a little bit like giving him a cash advance, and we have to make sure that all of that is spent on valid exempt purpose business expenses that are documented.
I have a form for a proper pastor discretionary fund if you email me. Get your list going, you know. You're going to have a bunch of things. This is the same problem.
It's the same issue. We have 3 or 4 in there. This one, we had a family they set up an organization to help kids with special needs, and nobody's going to dispute the fact that that's a charitable group. But unfortunately, they only helped the children with special needs of the founding families. So that does not work. Same thing with the organization that was formed. I mean, this could have been birthed right out of one of our churches. You know, you've got 5 orphan children, parents killed tragically. You want to help a fund. And even with my most sophisticated churches that I know have been to conferences and wherever, I'm always amazed at how many call me and say, this has been such a tragedy. Everybody wants to give money for this. You've just got to stop that somewhere in your tracks. And I will give you a hint. That means you have to educate your ministers on how you cannot do this. Because otherwise, you're just going to be sitting in service one day going, no. And it's going to be too late. The horse has left the barn.
Yeah, our financial secretary sits generally on the same row with us during church on Sunday mornings. And whenever the announcements are going on, she's looking for us to go. So she makes a note and calls us on Monday mornings.
We don't do that as often as we used to do it. And sometimes I just look at him and go, we still want to go to church here. Be quiet. All right, we're going to talk a little bit about a group of rulings here that talk about a concept of private benefit or private inurement. Now, just quickly, I'll tell you the fancy word inurement means that your church's assets have inured or gone to the benefit of someone within the church that has the ability to make decisions. Okay, so somebody in power has the ability to use their assets to their private purposes. Private benefit is more of a broader concept. It basically means that we let the assets of the church be utilized by another person for their private benefit, but that person wasn't necessarily an in charge kind of person. So the first one has to do with compensation paid in excess of the amount that was approved and designated. And we're going to save that topic for the compensation session that we're going to do after a little while. So we'll talk about approvals and designations of compensation, and we're going to talk about all that subject a little later. The next one has to do with a church was denied exempt status because it was started by a really small group of people. It was kind of all one family. And then they would make donations into the church, and then the church would pay their housing expenses, and the IRS was like, no, this is not going to work, guys. And then the last ruling on the screen is Frank's favorite ruling.
Yes. No, it's not my favorite, but it points out the importance of having an accountable expense reimbursement plan. It has to be in writing. That's been the rule since 1989. So if you don't have one in writing, you need to have one. I'll send you one. Email me. But the problem that you have is not just having the policy, but operating the policy. Policy requires documentation of the expenses that being sought a reimbursement. And a lot of times our pastors are not known for their great paperwork, okay? And part of the problem is I never recommend that a church business administrator approve the senior pastor's business expenses because it could have adverse employment opportunity problems for you. I recommend that a board member or a personnel committee member approve those expense reports. But part of your job is also to look at the documentation. If the documentation is not there, that's additional compensation to the pastor. And because that hasn't been approved by your finance committee or personnel committee or your board, then that means that it's excessive, and that means you just cost your church tax exempt status. So if you're reimbursing mileage, but you don't know where they went or why they went there, that's part of the problem. And pastors always want to pull out the counseling card. It's confidential. I can't tell anybody where I was. I can't tell them what I was doing, and I can't tell them what we talked about. And we say, that's great, then you weren't conducting church business, and we're not reimbursing it. Okay, if it's that confidential, it's okay to not have the details of what you were meeting over, but you need to know that it's church business. You need enough detail to say, this person, we met with Jim Jones and we were talking about teaching a class, or whatever it is, or Jim Jones and we're doing pastoral counsel. You don't have to go any further than that. We're not trying to get to their confidential information, but we need enough to prove that it's church business. Yes, ma'am.
You can't just say a congregate. You have to have a name.
Yes.
Yes, you have to have a name. Because congregate could be one of a few hundred or a few thousand, or some of our mega churches, one of tens of thousands. So that's not going to be specific enough to prove that it's church business.
And if it's a meal documentation, you have to list who's at the meal. So that is a legal requirement of documenting a meal. All right, we have a few more. Next one has to do with paying the living expenses for the president of the organization. And the payments for the expenses were not included on the W-2. Additionally, we made some loans, so don't go, stop. I'm not ready for you to go off on loans yet. And then the third thing that came out of this one was really kind of a surprising, the IRS addressed a surprising issue. Not surprising that it happened, just that they addressed it in this manner. And that is that this organization was so egregious in it allowing its president to make the decisions and divert funds, that in essence what happened is they said none of the decision makers could take responsibility for anything, so we can't trust them. None of the governing body could be trusted to take care of the assets, so we're going to revoke the tax exempt status because we can't give anybody in charge authority to have it. But this has to do with the living expenses. I want to go back to something you said earlier, and that is the number one reason we have pastors end up in jail is this. So we have pastors who have the church pay for a lot of their personal expenses, their living expenses, and they don't have it reported on their W-2. We're going to talk about reporting a lot during the compensation section too. So I don't want to belittle that point right now or belabor that point, but this is to let you know, this is kind of to tee that up, that it's important that we make sure everything goes on the W-2 that's taxable, and that didn't happen in this instance. The second thing that was really bad, which Frank is going to address, is the loans.
How many of you have loans to pastors? Go ahead.
I would just wanted to clarify the living expenses. Is that the same? Are you talking about the housing allowance?
No.
Okay.
No. How many of you have loans to your pastors? Don't have to talk about that a whole lot then. Good. It is virtually impossible for you to comply with the law and make a loan to your pastor. And I recognize the problem of high cost of living. I recognize the problem that pastors can't afford a house and cannot even afford a mortgage because their compensation is not large enough. But IRS looks at loans and taxes them immediately to them, and they have been known to revoke tax exempt status for the simple act of making a loan. Okay.
More personal, kind of just driving home, we had a couple of more rulings where we didn't have any internal controls and we paid personal expenses.
Yours is
now,
breaking up.
Mine is breaking up. It's cutting in and out.
Travis, do we have some more batteries for this one?
I don't know if we do. But I want to just quickly address your question about the living expenses. The living expenses would not be covered as long as they were designated as housing allowance. Other living expenses normally in these rulings are going to be credit card payments, kids' school fees, other types of things like that. Groceries, which are never covered under housing allowance. And we're going to talk about designation of the housing allowance a little later too. All right.
The other thing, short term, if you don't require your employees that have credit cards to pay back any personal charges immediately, that creates a short-term loan, and that can create also tax problems for you and can form the basis, if it's one of your leaders, the revocation. So don't let them accumulate those personal charges and then pay them off once a year or once a quarter. Make sure you're paying them off.
All right, and we're going to wrap up this kind of private inurement, private benefits section with a little bit of internal controls or intermediate sanctions. So what happened many years ago is that when leaders of nonprofit organizations did bad things, that the IRS didn't really have a lot of things they could do against those leaders. And so in 1995, Congress gave the IRS a group of sanctions that they could assess against leaders of nonprofit organizations when they did bad things and took money they shouldn't have taken or used money in a way they shouldn't have used it. Well, this is one of my favorite cases, which I've left in the outline because it's just so darn fun. And that is Ms. Farr. Ms. Farr had a really intrinsic mistrust of attorneys. So she kind of started this organization called the Association for Honest Attorneys. And it was really to help people who had kind of been shafted by their attorney. and to kind of, show them the way through the legal process. Well, Ms. Farr kind of took it a little bit too far, no joke intended, and that she actually ended up kind of practicing law without a license. And so the state of Kentucky sued her for that. So that didn't go well for Ms. Farr. And then in the midst of all that, the IRS came in and audited the organization, and they determined that Ms. Farr, who was the epitome of the great benefactor of society and working with these people, had never taken a salary from the Association for Honest Attorneys, but that was okay because she just had them pay all her bills. I mean, I could take a lot lower salary too if my organization just paid all my bills, right? And so what the IRS said is all those payment for living expenses that you didn't report on a W-2, those are all subject to these sanctions, these penalties we can assess to you for doing bad things. She sued the IRS or disputed that, and the court has come back and said that she owes both what we call first and second tier. So let me tell you what this translated into for Ms. Farr. When you have what we call an excess benefit transaction in a nonprofit organization, that's a transaction that shouldn't have happened, like Ms. Farr getting living expenses that they didn't put on her W-2. Then that individual has to pay all of those back to the organization. So the first thing Ms. Farr would have to do is pay back 100% of what she took. That's pretty stiff. Then the IRS gets their cut. The first tier penalty referenced up there is 25%. The second tier penalty is 200%. So by the time this is enforced, then basically Ms. Farr has an out-of-pocket cost of 325% of what she took to begin with. These are the rules that we tell people. You've got to play within the rules. We have to do things right. We have to report things. We have to designate things. We'll talk about it a little bit more in compensation. This just tees up the topic a little bit. But anyway, that we don't get a lot of court cases in this particular area of the law, but this was a great one to then discuss. Okay. Ooh, look. While he's not looking, I'm taking the power. It's mine, and I have it now.
I am so glad.
And that's fine, because we're going to move into unrelated business income, going out of the fun topic of private benefit and private inurement and all those great cases. And we'll talk a little bit more about those subjects when we talk about compensation in an hour or so. So let's talk about UBI and tax reform. So just to tee it up, anytime we say UBI, we are referring to unrelated business income. This is income that a nonprofit organization or a church would have to pay tax on in the event that you have any of it. The caveat for going into this section is we cannot answer your UBI questions from up here. The reason is that this is a very technical topic and has a lot of things you have to work through the maze on to come up with. So we don't give firm, pat answers if one of you raises your hand and says, we do X, what do you think? We're probably just going to say maybe. That's a prelude to that. But let's talk about tax reform, because we got tax reform 18 months ago, or now more like 20 months ago, I guess. And one of the things we got out of tax reform was a new provision on qualified transportation fringe benefits. Who in here has your church is operating a qualified transportation fringe benefit plan? Who in here is paying any type of fringe benefits that involve parking, mass transit, anything of that nature? Okay, well, apparently, we have one. Okay. Who in here has a parking lot? Okay, all right, so, okay, now we finally got it to apply to you. All right, good. I went through the easy ones. Well, basically what happened in tax reform was that all the benefits provided by an employer to an employee through a qualified transportation fringe benefit plan, which traditionally we have considered as paid parking in the area where you work, or a commuter van, or it was bicycle commuter expenses, or mass transit, buses, trains, things of that nature. Basically, tax reform came in and it said, we want all of those expenses associated with that benefit plan to be taxed. And instead of taxing the employee who's receiving them tax-free, we're going to tax the employer. And so in our traditional way of the nonprofit, because when we tax the employer like that, it means the for-profit employer just doesn't get to take a tax deduction for the item. And so we all understand that. I'm a CPA firm. If I paid for parking, I don't get to deduct it anymore. My employee still gets it tax-free. And as general with our nonprofits, we're kind of like, ha, 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 look at you, for-profit employer. We don't have to worry about it. Well, the Joint Committee on Taxation kind of threw you for a loop and threw you under the bus, literally, on the mass transportation tax. And that is, they said, oh no, nonprofit employer, who you do have like 20 to 22% of the employees in the United States, we're going to have you pay a tax on it too. So if you pay these expenses, we're going to have you take the amount of the expense and report it on a Form 990T and pay corporate income tax rates on it. So if you have a qualified transportation fringe benefit plan, you're paying for parking for your employees in the surrounding area, not they go to a conference and you have to pay for parking there. But you're paying for parking around where your offices are or your buildings are, or you have mass transit passes or anything like that. You do have to file a 990T and report that expense and pay tax on it. Then they threw us for another loop, and they said, oh, those parking lots. Do you know that's a benefit? It is a fringe benefit for you to give your employees a place to park. Now, we haven't really thought about this a whole lot in tax history, but we're going to think about it now. And so if you spend a lot of money on that parking lot, we're going to make you pay tax on that money too. So we spent about a year in the whole professional community, like trying to figure out how they were going to do this. And last December, the IRS kind of told us, and they gave us a grade out. But first off, I'm going to ask you this. How many of you have reserved parking spaces for staff? Not handicapped.
Including your senior pastor.
All right. Well, the first thing they told us is if you have any reserved parking spaces for staff members, you have to look at expenses allocable to your parking lot and then allocable to those spaces and pay tax on them. Then they said, outside of that, we're going to let you look at your whole parking lot out here. And if more than 50% of it is used for employees, we're going to make you pay tax on the expenses associated with what's used by the employees. This was the big out to the church world, because how many of you have employees that would take up more than 50% of your parking lots? I have to think, it's like the IRS had to sit around a really long time to come up with some way to get the church world out of this, because they were getting a lot of flack. And so in theory, what has happened and what came out with the ruling last December was a lot of professionals telling you, and you may have done this and not realized it, get rid of your reserved parking spaces so we don't have to think about this anymore. If you do still have them and you just have 1 or 2 reserved parking spaces, I'm not too concerned about it. This expense or your total unrelated business income / this expense would have to be more than $1,000 to incur the tax. And so if you're just talking about 1 parking space, you're probably not spending that much money on your parking that's allocable to 1 space that's going to get to more than $1,000. But if you do have a lot of reserved spaces, you should seek professional assistance in determining whether or not this tax applies to you. To my 1 or 2 people here that pay for any type of mass transit or paid parking for your employees, you definitely need to seek professional guidance and figure out if you should be filing and paying this tax.
Well, and there is unanimous consent between Republicans and Democrats to repeal this, okay? Before the election in 2018, the Republicans proposed a repeal. All the Republicans voted for it. What happened with the Democrats? They voted against it. Democrats took over in January. They proposed the identical same bill. Who voted for it? Democrats. Who voted against it? So I'm not trying to get political on you. I'm just trying to give you the reality of what's going on in Washington. Now, what happens if you're a politician and every survey shows that there is 100% support for this bill to repeal it? What do you do if you're a politician? You want your pet project added to that bill because you know it's going to get approved. And so they're all trying to load it up now on the Democratic side and on the Republican side. They're adding things to it. They won't pass a nice, clean bill that repeals it. They want to score political points, and they want to make sure that they have their agenda advanced because they know that there's 100% support. So we're in the middle of the logjam. You have to comply with the law until someone breaks the logjam in Washington, D.C., and I don't know when that's going to happen.
Okay, let's talk about some other things that are more obviously unrelated business income. So let's talk about coffee shops, right? How many of you have a coffee shop? A few of you? Okay. How many of you have a coffee shop that has like a storefront and you're open at 6 o'clock in the morning till like 10 o'clock at night?
Nobody.
Nobody. Okay, well, you're probably good then. This ruling goes to the fact that if we operate a coffee shop that looks like a coffee shop and works like a coffee shop, it's probably a coffee shop. And it's subject to unrelated business income. It would not be related enough to our purposes. The few of you who raised your hands probably have some sort of coffee shop operating in and around your services or buried in your building that your employees get to use. And it's really not accessible to the outside world. And those are fine. Those are going to be more for the convenience of our members and the convenience of our employees. And they're not going to create a real issue here. However, as with this particular ruling, they wanted to build community relationships. I bring this out to tell you that we have a little bit of a move in the religious organizations world or in the religious community to move into projects that are what I call covert evangelism. We're just going to sit around the coffee shop and talk about Jesus. And therefore, our coffee shop is related. This ruling tells us that does not work. And so while they have great ideas, and I'm not telling you it doesn't work for covert evangelism in the spiritual realm, in the tax realm, it does not work, okay? So know that if you're going to go into that type of arrangement, you're probably going to pay tax on it. The next one has to do with a restaurant. This restaurant, we have several of these kind of in Dallas. They are set up to operate as a training program. So they want to train individuals coming out of bad circumstances how to be cooks or operate a restaurant or wait on tables so they can go out and get other jobs. And in this particular one, I don't know why, but they felt like they needed to do as a pay-as-you-go kind of thing. That means if you liked the food and you ate there, you would leave $5 or you could leave $50, but nobody was really going to say anything about it. Unfortunately, they didn't train enough people. So they had really just everybody working in a restaurant. And the training program wasn't training but like 1 or 2 people, and the IRS says that's not enough of a training program to get it to be a related entity.
Well, by the way, unrelated business income is fairly simple concept for issue spotting. You know, it's a trade or business regularly conducted that's not substantially related to your exempt purpose. That's the gloss over it. Many times you're not asking the right question. I have a facilities use policy I'll be happy to email to you, but the question you should be asking is on facility type use and these fundraising activity stuff is you need to ask about property taxes and you need to also ask about sales tax, okay? Because California follows the flea market rule, which says that if you host a third-party group to your church and they're selling CDs out in the foyer, guess what? you're liable for the sales tax unless they have a California sales tax permit. Okay, so now if that group is substantially related, that's okay, but we get into operating a coffee shop. You know, Christchurch in Nashville lost their property tax exemption because they operated a coffee shop, they operated a bookstore, and then they subleased part of their facilities to the YWCA. Okay, so think about your California law for property tax exemption requires that your facilities be used exclusively for religious worship. Okay, so everything has to tie back into religious worship. If you are allowing another entity, such as another church, to use your facility, that may or may not be an act of religious worship, depending on whether you're charging fair market value rent and some other type factors. So make sure when you're asking for advice on unrelated business income that you go back and ask, okay, you've given me the federal income tax answer for unrelated business income. What is the property tax implication and what is the sales tax implications?
I thought you were going to tell them that they're asking the wrong question because they're looking at, with UBI, everybody always says, but we did this with the money, right? But we sent it to the mission. We used it to send kids to camp who couldn't afford to go. So with unrelated business income, it never matters what you do with the money. That is not part of the analysis. What matters is how you gain the money. And so the other caveat I tell you with UBI is it also doesn't matter, that's why it doesn't matter if it's a fundraiser. So we look at what the fundraiser is, not what we do with the funds we raised. So just be careful, the excuses you get is, well, we did all this for our benevolence fund.
Yes,
Oh, which one?
I had someone from our property tax department in Orange County have me switch to a welfare exemption so that it was a broader category that we could host things on the campus.
So did everybody hear that? They actually had somebody advise them to switch to a welfare exemption. So in the property tax office, so this is where we get to tell you that property tax issues can be very dependent on who's sitting behind that desk, right? And who's really talking to you. And so a lot of times if you're going to change your operations or you're entertaining doing something new on your property, before you do it, it pays to have a conversation with someone that says, if we do this, are we going to lose our property tax exemption?
And I've had really good luck, if you want to call it that, but I have really good conversations with the tax exemption officers in several California counties, and these are good. The ones I've dealt with are good-hearted. They're trying to help you comply with the law, and I really appreciate that. So they bring up all kinds of different information and different filing status, and I've also found that from county to county, I know we're in Orange County, we're right next to Los Angeles County, most of them they're trying to find a way to get you to exemption. And I have had them more than one occasion ignore violations. So don't think that it's right, but that's what they're doing.
Yes, sir.
If it's a separate entity, can it donate 100% of its profits to the 501c3?
So doing work in a separate entity is not a part of unrelated business income. Okay, this is an activity that you're conducting in your entity, in the exempt entity. Okay, it's not activity that we have dumped into a separate entity.
It says organization formed to operate a coffee house, not...
Right, but they tried to get exempt status for this organization.
Now, you cannot donate and deduct 100% of your profits. We have something in California called a social enterprise that allows you to consider social good as part of your purposes in a commercial for-profit entity. So One of the common ones is the board of directors doesn't owe a fiduciary duty to maximize value to the shareholders as much as they also have a fiduciary duty to protect the environment. That would be one example of a social enterprise. So there are all kinds of ways to get there, and that's why you need professional advice, someone who's really knowledgeable in the nonprofit arena, and not just any attorney or any CPA. Yes, sir.
I have a quick question. If we were, as a synagogue, to open a small Judaica store to sell things to our members and or the public, how does that apply to us?
So what we have is opening like a store, and that's the last one up here is like a bookstore. So most of the time, our bookstores and our religious worship centers are not unrelated business income in and of themselves. In other words, the whole bookstore is not unrelated. They're usually operated for the benefit of perhaps our guests that come through or our members, and we don't have a big flashing sign outside that says bookstore here.
Is there any difficulty with the fact that we don't have them open during services?
No. That actually promotes the idea that it's for the convenience of your members. We're not operating it during services. Now, with that being said, that's your whole operation. Within your bookstore, you can all be selling things that are unrelated business income. In other words, it doesn't make everything you decide to sell in there related to you. So when I go in and I see teacups and jewelry and certain t-shirts or artwork, things that really are not related to our exempt purposes enough, then that church may owe unrelated business income tax on the sale of those items. So with the bookstore, you have a twofold analysis. Number one, is this the ruling that says my whole bookstore is taxable because it's really a commercial enterprise? And number two, what am I selling within the bookstore that would be taxable? And there's all types of rulings out there, and they're kind of a little bizarre to give you warnings about how you determine what you sell in your bookstore is related and not related. And so sometimes that takes, for instance, I've done jobs for a museum where I went into their bookstore and looked at everything they sold. And then we determined what was UBI and what was not UBI. And so if you have a larger bookstore, it is something to consider. Did you have a question, ma'am?
Yes, we have about 3 acres, and we're looking at opening, allowing a charter school to come on board.
Okay.
And the income, like for a year, they're just gonna pay us rent.
Right, so they have a larger campus, and they're looking at a charter school coming on board and renting a part of it. Rental agreements can go either way. And there are a lot of different factors on what makes a rental agreement even related to your exempt purposes or not related. I would tell you that I have situations I deemed the rental to a charter school unrelated, and I have situations I've deemed it related based on the individual church I was working with. Also, when you get into any type of rental or facility usage, you are also looking at a myriad of other factors, whether or not it's debt financed or not, whether or not we have services we're providing, whether or not we're renting personal property in addition to our space in our building. And so rental questions are some of the most intricate UBI issues we actually look at.
Complicated.
Very complicated. So Frank had a client that came to him and said, hey, for instance, we sold a piece of property that was commercial in nature, and our tax preparer had us pay tax on the gain on the sale. And it was about $175,000 of tax. And so Frank's talking to them, he goes, I don't think selling property, generally that gain does not create unrelated business income. And so he looked at it, and they did determine that the gain on the sale wasn't taxable. And so we came to me, I filed the amended 990T, and that church has now received their check back of $175,000 in tax and about $11,000 in interest on that tax. And so what you have is, and at the same time, at the exact same time we were doing that, I had another church come to me, and they had had a professional analyze whether or not their rental income from a strip center, like a shopping center, was unrelated business income or not. And there's a really unique factor in unrelated business income when it comes to rental income that the professional firm, the other CPA firm, had totally ignored. And they had told them it would not be taxable, and their rentals were taxable. So I did deliver that bad news. So it is a really complicated area to deal with rentals and facility usage questions.
Yep.
So if you have somebody, you let somebody use your facility, they come in and they teach something, say a biblical class or something, and they charge for it, are we taxed, are we gonna be taxed for that?
Well, it depends. You know, you bring someone, allow someone to come in and they're going to teach biblical principles using your facility. First of all, is it a for-profit entity or a nonprofit? If it's a for-profit, if it's a sole proprietorship or an LLC or something, then you absolutely have to charge them full fair market value rent. If it is another nonprofit, then you probably don't, but that could also create problems for your property taxes. And it could create problems for sales tax if they're selling product also. So you gotta go through the analysis. There's not any black and white answers here. Yes, ma'am?
I have a question on the cafe. So if you have a cafe operating before and after church services, but you do pay California state sales tax, are you within the right guidelines for this, or?
Well, for federal unrelated business income tax, you're probably fine if you're just operating it around service times. For property taxes, you're probably fine because isn't eating a religious heavenly purpose? Don't we? Yeah. I've never met a church yet, or temple or synagogue, that religious activities revolved around food. So I don't have any problems with it. Okay.
All right, moving on.
You got the buttons.
I've got the buttons. Okay, so we're gonna.
I didn't update that one. All right.
You didn't update. Okay, we're gonna have to move on pretty quickly through payroll.
All right.
But some of the payroll we'll talk about in compensation, but this is one of the issues we're not, and it's not updated, you're right.
Yeah, the DOL announced last week, $684 is the minimum salary. Now, I know California uses 2 times the minimum wage, but this is going to impact some of you. Okay?
So this has to do with your classification of your
Because right now,
exempt
the larger
versus
employers
non-exempt
are $12
employees.
an hour, and if they're full-time employees at $12 an hour, that still may not work out because that's, you know, on a 40-hour week, that's $480. So that's not going to hit the 679
And
or
it's
684.
684. I think it's right in the handout. Didn't
Yes.
you correct the handout?
I did correct it in the handout.
We just didn't correct this one.
684.
This is what it has been proposed for like 3 months.
And that effective 1/1 of next year. So you just need to be prepared for that. I'm going to talk in a minute about ministerial exception, but you need to be reviewing all of your employees that are making more than $455 a week and $684 and determine their status, whether you're going to have to flip them to non-exempt as of January 1.
So that takes priority over any state law.
No, state law is more generous. You have to comply with the law that's the most generous to the employee.
The next one has to do with Pastor Brown. He had a couple of different issues going on. Number one, his housing allowance did not get properly designated. So the church had not designated his housing allowance in writing, and so the IRS taxed it, and the court agreed that there was no written documentation of how much he should be getting in housing allowance. This goes to just drive home the fact that the church has this as its primary obligation on doing housing allowance. You don't have to you don't have to know whether or not the minister spent it all or what the fair rental value is or if he can exclude it all. But the church does have to designate it in writing in advance of payment. Pastor Brown also had a second little tax issue going on, and that is that when he was given love offerings, he was not reporting those. And so when he admitted leaving his love gifts off his tax return, the IRS taxed him on those and said you have to pay taxes on that.
Love gifts are always taxable, even if they don't go through the church, even if you don't count them. Now, if you have a money tree out there or a basket that you have put cards in and people put a check inside or cash inside, those are still all going to be taxable. And if the church was involved at all, that goes on the W-2.
So Pastor Felton, the next case up there, has a similar tax issue, although his church was much more inventive. His church had multiple colored envelopes. So, green went for one purpose and white went for one purpose, but blue envelopes you could obtain from an usher. And if you put money in the blue envelope, then you just gave it directly to Pastor Felton, and Pastor Felton did not report those as taxable income. Unfortunately, the IRS disagreed with Pastor Felton's tax position, and the court agreed with the IRS. And so said that, in essence, the money being placed in the blue envelopes was just another method for the congregates to compensate Pastor Felton for all his great work as their pastor. We are really lucky that we are reading about Pastor Felton as a tax case and not as a criminal case, because every pastor who has gone to jail for not reporting love gifts. That has been a piece of where they have underreported their income and been convicted of tax evasion. So Pastor Felton is getting off easy if he's just getting a civil tax bill. And then housing allowance.
Housing allowance is constitutional, and the Freedom from Religion Foundation has said they've given up. They're not going to be filing anything else for the time being until they get new leadership. So.
All right. I skipped a couple in there, but let's go to HRA rules. We have new HRA rules coming, and you're thinking, oh my gosh, we can't figure out how to run the last ones. So a little history is basically the ACA made it where you could not create a health plan that reimbursed employees for any individual health policies, including Medicare. So if you have a health plan that is reimbursing individual health insurance premiums, including Medicare for employees, you probably are not ACA compliant right now. And you have a whole nother issue to discuss with a professional. President Trump did hear kind of the outcry against this. We've been complaining about this for 9 years. And so he instructed the Department of Labor and the IRS to kind of come up with a new HRA plan that would allow for that. So effective January 1st of 2020, it is possible to operate a health reimbursement account that can reimburse for individual health plans, including Medicare, supplemental premiums. There are rules. Who's surprised about that? There are hoops to jump through. You cannot offer it at the same time you're offering them group health insurance. That's one of the issues. So there are ways to construct it, but they do require that the plan be created and that notice be given 90 days before the beginning of the plan to employees. So if you're interested in pursuing this, all the fringe benefit companies out there that will offer kind of standardized plans are already creating these plans and are already offering them to people. You can pursue that maybe with one company you already use, or get some consultation on how do you work this into currently what you're doing. It may be that you're actually doing this and it hasn't necessarily been within the confines of the law, and now you'll find a way to do it and continue it. And we're going to skip that. The last thing we're going to talk about before we take a break and Frank goes to HR, is just a couple of issues on charitable contributions. The first I do want to talk to you about, and there's not a case on this. This is just Elaine's dealing with a lot of questions on how many of you are getting contributions that are qualified charitable distributions from somebody's IRA account. Okay. And so that's a great tool. It's been made permanent. If you're 70 and a half or older, you can give a contribution directly from your IRA to your charitable organization. It doesn't get reported in the IRA account holder's income, and they don't get a charitable contribution for it. Because of that, I do ask that you do not include these on their charitable contribution receipt that they get with all their other contributions. They should be receipted, and has been stated they're required to be receipted, but you need to do so on a separate receipt. So don't include these, because I can guarantee you if you put it on the same receipt with all their other charitable contributions, they're going to hand it to their tax preparer, and their tax preparer is going to deduct it. They're not going to know. So just internally, this is kind of a heads up, and I give this to you because I've had like 5 questions on this in the last couple of months. I'm going to skip that one. I'm going to wrap up charitable contributions with the fact that in your handout is listed multiple rulings that we've had where people who have given bags of things or household goods or whatever are not getting to claim those deductions because the receipts they get from Goodwill or Salvation Army are not sufficient. That's a big shocker, right? You've all dropped off your bags of things and gotten the 3 by 4 inch piece of paper that you get to fill in yourself. Funny thing is the court says that's not sufficient. And so this is kind of just to let you know, if you are doing anything where you're accepting non-cash contributions, make sure your contribution receipt should never have an amount on it, but it should at least describe the items in some way, shape, or form. And it also must have the no goods or services statement on it. And if you give a separate letter or receipt for your qualified charitable distributions, it also has to have the no goods or services statement on it.
All right. The California legislature last Friday handed you a wonderful present signed by the governor. This will be effective January 1 of 2020. This is redefining contract labor. Now, by the way, this is I think it's your number one tax exposure, is treating people as contract labor instead of employees. And the new law says there are 3 criteria. If you fail any of these 3 criteria, you're automatically an employee, starting January 1. The first one is no control over the work. You control the results only. So if you have a landscape person and you say, I want the lawn taken care of, I want it nice on Sunday, you don't give them any tools, you don't give them any guidance, you don't tell them when to do it, it just has to look nice on Sunday. That would be an example of contract labor. But if you say, look, I want it cut 2 inches high, I want you to clean out the flower beds over here, I want you to trim this tree up. Once you start getting into the details, you flunk that test. That test, by the way, has always been the test. The second one is it's not integral to the company business. And we don't have a definition of that in the nonprofit sector, but because it's so new. But think about it. What part of church isn't integral? The most common contract labor I find out there is musicians. And how many are you going to argue that music isn't part of our religious worship service? I don't care if you're Church of Christ. It's still integral to your religious worship. That's some of the best 4-part harmony I've ever heard. Is when I've gone to my Church of Christ clients. So, if they are, let's talk about, you want to use someone contract labor in the finance office. Are you going to argue that finances aren't integral to your church? Okay? This is intended for people that are one-offs. So, like, if your air conditioning breaks, and you need someone, contract labor, to come out and fix it. That's not integral to the operation of church. Although in Texas, where it's been 97 degrees this week, I could argue that. But this law doesn't apply in Texas. So that's going to eliminate teachers. That's going to eliminate a lot of nursery workers. Who wants to argue that the nursery workers, and besides, you want them under your control. Period. You want a background check and train them. And then the third one, they must perform services for multiple companies. Yes, ma'am.
What about your musicians who perform or?
They flunk the first test, so they're employees.
But
Always. Always. I don't care how temporary they are. We've got cases out there. By the way, the score last time I added it up was 3 years ago. It was 25-0 for musicians in favor of employee. 0 wins for contract labor. And in fact, one of those cases dealt with the Plano Symphony in Texas, another one in the Pittsburgh Symphony in Pennsylvania, and you had a substitute musician who came in and performed 1 2-hour concert. One. They're only on the payroll for 2 hours out of the entire year. What did the court say? Employee. So I don't care if you're bringing them in for special services at Easter or Christmas. They are employees. I don't care if they bring their own instrument. They are employees, even under current law. This is going to make it impossible for them because you have to meet all 3 of these to be an independent contractor. Now, the part of this that I don't like is $5,000 to $15,000 per worker that you call an independent contractor that flunks this test. The $5,000 to $15,000 depends on the size of the church, the number of employees you have.
Is that as of 1/1/2020?
1/1/2020.
It's as of then.
That's as of then.
So we have time.
Okay? Yeah.
The janitor that works for, you know, I know that you have to have your place clean, but is that kind of like the gardener where we just want it to look nice? And
Well, a janitor service is probably going to be okay because you're not in the business of cleaning buildings. But again, you can't control the details. That's where the janitors typically fall. But this is 1/1, and this is going to make it extremely important that you reclassify people to employee status as of 1/1. The other thing is IRS has an amnesty program going on right now. And you've only got this month to file for it to make it effective January 1. And if you file, there's a form, and Elaine and I can send you the information, the links. It's really, you don't need a CPA or an attorney to fill it all out. We're happy to do it. But you pay 1% to 2% of the 2018 amounts for those 1099s that you file, and then you classify them. The IRS gives you permission to reclassify them as of January 1, 2020, and they promise never to go back and look at penalties or anything else. So you need to get on the stick on that. You've only got about 3.5 weeks to get that filed. Yes, ma'am.
Does the hours a person works have anything to do with this?
Does the hours have anything to do with it? No. As I told you, 2 hours. It could be as low, I've seen cases where it was low as a half an hour. Okay, so no, that doesn't have anything to do with it. Yes, sir.
So you're saying that if this occurred in 2019, the musicians that we hired for Easter, they're okay because it was 2019, but we give them a 1099.
Now, I'm not saying it's okay in 2019. The penalties are what scares me in 2020. You need to convert them over per IRS and also so that you can comply with California law. Yes, sir.
So I have 2 questions. So just to be clear, so a pastor goes on vacation, you have a guest speaker come in, you pay him, he's an employee, right? Is he?
No, because you're not controlling the content of what he preaches. Okay? So the first one, all you're saying is show up and say what God tells you to say. That's the only control you have. The second one, is pastoring integral to your service? Yes, it probably is. So under the new California law, they may be an employee, come to think of it. Again, I've only had since Friday to look at this. Yeah.
So if you have legal issues in your church, that's integral to your church, right? So if you hire some lawyer.
But what we haven't got to yet is this is a half a page of the statute. We now have 4 pages of exceptions. Typical California lawmaking. Okay, we're going to make this general rule for the uninformed, and then we're going to make all these exceptions for the lobbying groups, right? one of the lobbying groups, if they are a licensed professional, doctors, lawyers, I would put pastors potentially into that, although they're not CPAs, not bookkeepers, but they have to have a professional license of some sort. That's one of the exceptions. The other exception that we don't really know, but we know that part of California that's just a little north of here said that an exception is for fine art. Fine art, F-I-N-E-A-R-T.
So
music director.
Well, who knows where, I think what I've been able to figure out is that, by the way, the movie companies are already, all your extras are employees, by the way. All your directors are employees. All your musicians are employees already. So I haven't figured out what fine art means, but I think that the only safe route for the church is to convert everybody that you have a regular relationship with to employee status. Otherwise, you're going to spend a lot more than $5,000 with me litigating that case to figure it out. Yes, sir.
And on your first point there, so I have, say, a music director that's an employee, and I consider her exempt, and she works 20 hours a week, and we pay her $342.
Wow. We're going to talk about her in a moment. That's not correct, but
Part-time versus full-time.
no. Well, we're going to talk. But in the top point up there, that's $684 part-time, full-time. That's the minimum salary, period, per week to be non-exempt. To be exempt, I'm sorry. Anything less than that is non-exempt.
But there's exemption tests.
But yeah, in California, it's 2 times the minimum salary, which is $12 an hour. Okay? Now, you bring up a great transition for me, and this is called the ministerial exception. And most churches don't know this very well. And I'm finding lots of ignorance out there, and I'm also finding lots of controversy out there over it. This is an exemption that has been around since the 1980s. And what it says, per the Supreme Court of the United States, is the relationship between a church and those spiritual employees is so sacred, the First Amendment prohibits the government from regulating it. And what that means is California employment laws don't apply, federal employment laws don't apply. There's not a single employment law applies if the position is subject to the ministerial exception. And we have about 140 cases out there on different occupations within churches, whether they qualify or don't qualify. So one of the most important things you can do from an HR perspective is go through your job descriptions and let's find out who is subject to the ministerial exception. The reason I say that is this is different from the ministerial exemption for tax purposes. This is not the same law for housing allowance. This is labor law. This is constitutional law. And so you have to, a lot of times we've gotten sloppy with our job descriptions, and we have not included spiritual duties and responsibilities. What we did is we copied something off of the internet. And so, for example, your worship director, are you going to require them to be a Christian? Probably, right? What sort of education are they going to have to show that they understand and will follow Christian doctrine as your church practices it? That's probably not part of the qualifications. What sort of training have they had spiritually in order to perform that job? So then we look at the job description itself of the activities, what they're responsible for. If we say that religious music is an integral part of our Sunday worship services, is that person in charge of creating that worshipful atmosphere, selecting the music and leading the congregation to use the psalmist's words, into the throne room of God. Can you think of anything that's any less spiritual than that, that they're doing? So, and then when you review them, we pull these reviews off of the internet, but what sort of spiritual criteria are we using to evaluate this position? In this worship leader, are we, in our formal review process, are we saying, how are you doing on that? How's your spirit? How are you conveying the spiritual values of our church through the music? How good a job are you doing on that? And then finally, do we send them to religious continuing education? So, do we send our worship leader to worship conferences to learn how to do worship better in a church setting? Do we require them to do some of that? Now, you don't need all of those, but you need a lot of them. And in that case, 100% of the cases have said that a worship leader for a church is subject to the ministerial exception, just like a pastor is. Okay? But you get it a little crazier when we venture outside of those traditional public roles of ministry. We have situations where we're dealing with media directors, all right? If the media director is doing nothing more than recording the worship services, editing them for YouTube or our website, that probably isn't a spiritual position. But if they're creating content to go on the website and they're selecting video to convey the worship in our church, in our doctrine, in our teaching, then I can see how a media director could also be subject to the ministerial exception. So what you have, it's a position by position, and the DOL guidance on this, Department of Labor guidance, says that the titles that we give are also important for the minister exception. If you got pastor or minister into the title, that's some deference. That's one of the factors that goes into the ministerial exception. So you're in a Presbyterian church and you have a children's director. All right, they're in charge of the children's ministry of the church. Do we require them to be a Christian? Typically, yes. Are we going to require them to have some religious training in Presbyterian doctrine? Yes. Are their job description include conveying and teaching the Presbyterian doctrine to our children? Yes. Are they being evaluated on how well those children are learning those religious principles that we're teaching? Yes. Are we going to send them to children's ministry conferences to learn how to do children's ministry better? Yes. That children's director is going to be subject to the ministry exception, even though they're not licensed, ordained, or commissioned by the church, because they're not part of the ordained clergy for the Presbyterian church. So I can see it for children, I can see it for youth. When we start venturing around, but make sure that your job descriptions match that. All of those factors in there. And now that I've explained what it is, let me put the caveat on it, and that is sexual harassment is both an employment law, and it's also what lawyers call a tort, which is a common law cause of action, because it's unintentional. It's an intentional infliction of emotional distress. It could be assault. In this case, we have a Catholic parish. We have an employee who is gay, and as we all know, the Catholics believe that being gay and practicing same-sex relations is a sin. So this priest is berating this person. They're pointing out their sin. They are creating a hostile work environment. And ultimately, the priest fires the staff member. The staff member sues the parish for the hostile work environment. And while the priest could not sue because of the ministerial exception, the non-ministerial employee could absolutely sue for sexual harassment. And the parish is liable for that. So there's a parameter out there. This is a big case, the Beal versus St. James. And the reason it is such a big case is in June, the Ninth Circuit, which covers California, had what's called an en banc decision, which is all 35 judges got together and voted on this case. So this is about as strong a binding precedent you can get for California. And it said that a Catholic high school teacher teaching Catholic doctrine was not subject to the ministerial exception. And the reason they gave, the primary reason they gave, is because she was not ordained or licensed or commissioned as a priest or a nun. That is blatantly against the Supreme Court authority, but that's not the first time the Ninth Circuit has sort of ignored Supreme Court authority. So the reason this is important is they're trying to narrow the ministerial exception down to those that are licensed, commissioned, or ordained. We have 140 cases out there that say that it's not. And we now have one that says that it is. So I'm hoping the Supreme Court will take this case and correct the Ninth Circuit on it. Yes?
My question is, according to the IRS, you have to perform so many functions of the sacerdotal or sacerdotal duties.
That's an IRS rule on sacerdotal funnies. The duties of a minister are defined by IRS. They're not defined for Department of Labor. Those don't have any crossover. Not applicable at all. So they don't have to perform sacerdotal functions. The main thing they have to do is they have, and my word is non-delegable spiritual or religious responsibilities. Okay?
Well, I want to emphasize that, though, because what you just breezed over is very confusing.
I'm not confusing. They're
Yeah.
just confused listeners. I know what I'm talking about.
You bring up a common confusion, and that is you have to understand what law we're talking about and which ministerial definition we're talking about. So when we talk about employment law, which is wage and hour, discrimination, those in contracts with our ministers, when we talk about Department of Labor issues, we're talking about the ministerial exception that Frank's been talking about. That definition is very different, and you have to go through all of your employees because he's just said you don't have to have credentials to be treated under the ministerial exception for employment law. So you should go through all your employees and figure out which ones for employment law do I have ministerial exception covering. That's pretty important because that means you don't have to pay them minimum wage, or you can work them 100 hours a week and pay them $20. I mean, you know, so, but that's labor law. IRS definition of a minister is for payroll tax law of FICA and Medicare and housing allowance.
And income tax withholding.
And income tax withholding. That is a different definition than what Frank is talking about here with ministerial exception. All right? So you have to also classify your workers on who's a minister for IRS purposes in order to know how to treat them for withholding purposes. Yes?
For, let's say for like a youth pastor, they are a pastor, but if we, can we apply the ministerial exception if they're an hourly employee, or do they have to meet minimum wage requirements, period, if they're a ministerial exception in the state of California for a youth pastor?
If you meet the ministerial exception, you do not have to meet wage and hour rules.
Period.
So we don't have to worry about meeting that minimum wage requirement?
Correct.
Period.
That's why it's so important to make sure you know who I get to treat as under the ministerial exception. And then at the same time, you need to figure out, now, who do I treat as a minister for all purposes of payroll tax withholding and reporting and housing allowance? Those two definitions are not the same, and it won't be the same group of people.
Okay?
So if you have a teacher in a school, can you prohibit them from teaching things that are contrary to your particular religious doctrine without, so homosexuality is improper in your religious doctrine, can you prevent them from teaching that it is okay?
Well, that's a different question than cover. Well, you can do anything you want until you get sued, but I think that it goes back to your Christian school, whether you're a religious employer as defined by California law, and if you are you're a religious nonprofit corporation, and there are lots of different factors that go into that, but the short answer is, with proper legal guidance, you could accomplish that goal. But it's a more complicated analysis, yes.
So I know the exemptions, I know there's like the professional, the administrative, and this is the third one, the administrative, right?
No, it has nothing to do with any of those, because you never get to that.
Yes, so the first thing, I describe it a little bit like this. Let's put all your workers on the table. And the first thing you do is you go through all your workers and you figure out who meets the ministerial exception. Okay? You document it, you get their job descriptions done upright, you make sure they meet that, and you take all those workers off the table. They're not there. Now you have everybody who's left. Now you're even going to think about exempt versus non-exempt with who's left on the table. So the ministerial exception, you should apply first to all your workers, and then you move into, okay, who are my exempt workers and who are my non-exempt workers?
Because pastors can never be exempt or non-exempt because the law never applies to
You don't ever get to that question with your ministerial exception people.
So one of the California state law cases that's in your handout deals with daycare workers. And by the way, I think Beal is wrongly decided. I've made that obvious. The state court decision that's in your outline, but it's not on the PowerPoint, is correctly decided. A synagogue operates a daycare center. And the child care workers, the state of California sued to get minimum wage and overtime for the child care workers. By the way, the very first minister exception case I had was for child care workers in a daycare center. And the reason I think it's wrong is, first of all, they didn't require them to be Jewish. What they did do is they gave them 2 days of training by the rabbi on Jewish tradition and Jewish law and Jewish practices, and they then taught what they were taught by the rabbi to the children. They were not considered a religious leader in any sense of the word. They're just conveying what they were taught. And because they were not required to be Jewish, and they were not required to have any formal education beyond the 2 days that the rabbi gave them, then the minister exception didn't apply. But you got cases on the other side where you require your preschool workers to be Christian. They're required to have gone to Sunday school for so many years. They're required to have formal Christian education, whether it's through your church or through a college or university or seminary. You give them religious duties and responsibilities to convey the doctrine of the church to the preschoolers and teach them the Jesus Love Me songs and all of that. They pray with the kids. They practice the faith with the kids to help build their foundation. In that case, the minister exception is likely to apply. But that's why you have to go to the ministerial exception, and that's why I recommend you identify those places that are on the fence, so to speak, and get a lawyer to help you with the job descriptions and make it really clear which way they're going to be classified. Because
After you finish figuring out everybody who meets the ministerial exception and you take them off the table, you're done with them, then you're going to look at your employees. And the first question I think you ask is, how much does everybody make who's on the table? Because you've got to get this weekly minimum wage met. And because if somebody doesn't meet the weekly minimum, either required by the most conservative one, or required by California, required by the federal, then they're gonna be a non-exempt employee. Doesn't matter what they do. They're a non-exempt employee. And so you have to go through this kind of piece by piece, looking and just keep taking people off the table into each bucket until everybody's classified right.
Is ministerial exception explained in there here anywhere?
not really well. Because it's been around since 2012, the Supreme Court decision, and the doctrine has been around since 1987. I did the ABA webinar right after the Supreme Court decision, and I can send you that handout, and it explains it a little bit more. But it's, you know, the cases are all over the place.
So we'll introduce the book now. Last year I published through Christianity Today, the church compensation from strategic plan to compliance. One of the chapters in here is on wage and hour. It does briefly discuss the ministerial exception and kind of gives you a primer on what you should do. Your gracious host today has volunteered to provide anyone who wants a copy of this book with this book. So you will just need to let them know that on your way out. I think it covers all aspects of compensation, which we're going to talk about a little in the last few minutes. And I tried to make it as readable as I could make it. My clients have told me the examples are great, and I told them that's because they were all based on real life. I didn't make any of them up. And so anyway, but please, I have a couple of copies up here if you want to look at it before you make the request, but do know that your host is willing to provide this to you free of charge.
What's it called again?
Church Compensation from Strategic Plan to Compliance, put out by the Church Law and Tax Group of Christianity Today.
Okay, I need to wrap this up because you need to get started. The one I wanted to point out to you is and we have this case where a Methodist, female single Methodist minister became pregnant. Okay, Pregnancy Discrimination Act says you may not take any adverse employment decisions based on the pregnancy of a woman. The church fired her. Minister exception says, absolutely, church, you have the right to fire because the minister exception applies, okay? But we contrast that with a program director and a child care worker, okay? Those are not subject to the minister exception. That's what the court said. You may never, unless the minister exception applies, you may never terminate a single female employee before becoming pregnant while she's working for you. I don't care if that's contrary to your doctrine. I don't care if you don't think it's right. I don't care if they're a teacher. You may never fire an employee because she's become pregnant and she's single. Am I pretty blunt on that? Don't go there. That's part of why the minister exception is so important. Because on the minister exception, the Methodist minister we were able to terminate for doing that because no employment laws apply. But we can't do it for anybody else. The last one I wanted you to give pardon? So what we have to do, the last one is really important, and that is they passed an ordinance in the city of St. Louis that said that you may not discriminate on the basis of sexual orientation. It did not include an exception for churches. And the churches sued, and the court said that it was unconstitutional not to exclude the churches. So that gives you, if your faith group wants to discriminate on the basis of sexual orientation, this says that the government cannot force you to. And that's why that's a good decision.
Well, we are going to keep talking about compensation a little bit. I don't know why we have a little thing up there. Oh, it's going to go away. Okay. And so we're going to move a little bit more into compensation. Several of these topics in here we've actually talked about over the last 3 hours. And so we'll put some of the pieces together. This is my basic building blocks presentation on compensation. When Christianity Today approached me and they said, we want you to write a payroll book. I'm a CPA, write a payroll book. That seemed logical to them. I was like, no, I'm not writing a payroll book. I said, compensation is more than payroll. And it affects so many more people in the church that I will write a compensation book that then encompasses everything for you. That has payroll is definitely a piece of it. It is. But it helps everybody put the pieces together. And so I tell people in the preface of the book I said, there's something in this book for everybody. I'm not saying everybody's going to want to sit down and read it from front to back. That would be awful. Only I should have to do that, and my editors. But there is something in here for everybody who deals with compensation. And so this building block speech is really to talk about some core basic foundations to compensation planning that help keep you at a lower risk, because one of the number one ways a church writes a check to the IRS is because of payroll problems. When something happens, and either worker classification, which we've already talked about a little bit, we're going to talk about fringe benefits, how they don't get reported right. And so all of that's kind of built into this. But we're going to start with some foundational items. And the first thing you want to do is you want to figure out who's making the decisions. Anybody ever work for a church? You're like sitting around going, I don't know who to ask for this. I mean, who do we get to make this decision? But believe it or not, you really do need to know when it comes to compensation, hey, who is supposed to be making the decisions for what employees? So yesterday we got a great question that was like, does the same person have to make all the decisions? And the answer is no, the same person doesn't have to make all the decisions. You can have a committee or the board making senior leadership decisions, which they should be, and then you can give senior leadership the ability to make rank and file decisions. But whatever you do, somebody needs to know that's their job. Right? Because that's who you have to then educate on how they do that job. And you want to make sure that whenever anyone is making a compensation decision, that they're independent to the person they're trying to make a decision about. And so this means that if it's a committee, you don't want a family member of the senior pastor on the committee making compensation decisions. I mean, he may want a family member on the committee making compensation decisions, but that's not going to be independent, and we can't have that going on. So you want to make sure that you know who the decision makers are and that you confirm that they're independent. Now, let's say that we do end up and we have a committee member who happens to end up being related to someone who's being compensated. That's not a death nail, but they don't get to vote on that compensation. They don't get to make that decision, and maybe they have to excuse themselves from that. The other way you get independence issues is that, I know y'all are going to be surprised by this, but the IRS says that if you're making a decision about compensation for someone who's over you in the organization, you're not independent. I mean, I guess they think you can't set your boss's compensation without being a little biased one way or the next. The related is the other issue, and then the other issue is if you had outside business interest with them. So if your pastor's 50-50 partner in a for-profit business out here, his business partner cannot be making compensation decisions for him. Building block number 2 in the world of compensation is going to be to define the position. This has to be, we have to know what we're paying for. And Frank's already talked about ways we want to create job descriptions based on the whole issue of determining ministerial exception and wage and hour rules. And So what's happening in the industry as a whole is that your job descriptions are just becoming very, very important to everything you do. And this goes to defining the position, clarifying with people what they have to do, what they don't have to do, knowing who they report to, knowing where they are on the hierarchy chart, knowing whether they're subject to the ministerial exception or not. Now, how about knowing whether or not they are supposed to be a credentialed or licensed minister? I was reviewing job descriptions for the ministerial staff of a megachurch in Texas the other day. Not one of the job descriptions said they were supposed to be credentialed. I'm like going, you might want to put this in here that you expect them to hold credentials, because this is important. If the IRS ever comes in and questions this position, they need to know that it has to be held by a minister. So it's important to get some of those definitions on into the job description so we know what to expect out of this and how to classify them. Additionally, for wage and hour, I think your job descriptions can define whether clearly so the employee knows, is it an exempt position or a non-exempt position? Will you expect to keep them on the clock? Do they have to turn in timesheets because it's a non-exempt position? I don't care your pay structure you have for an employee. If they are a non-exempt employee, you are required to keep time records on them. That is mandated. You don't have a choice. Just saying that you're going to pay somebody a salary does not make them a non-exempt employee. That's a pay arrangement, not a classification. Building block number 3 is the one that gets a little more complicated, and that's now that we know what we're paying for, right? Now we know the position. Now what we want to do is know how much we can pay them. And this normally it requires us to gain outside data. Now, for your leadership positions, the Internal Revenue Code basically requires you to go out and find outside data to justify salaries for leadership positions. So some of the ways we get outside data are through salary surveys. Anybody ever use salary surveys? I put a couple up here. Okay. Anybody ever used a compensation expert? Like got a big fat report. Those are 2 of the biggest ways we gain outside data. Anybody ever called 5 sister churches to figure out what they're paying? Yeah. So you've done everything. You have all kinds of outside data, don't you?
I do. Unfortunately, they didn't have a salary structure before I got to where I'm at now.
So you're building it. And so those are all ways. Anybody ever, how about you never ask anything or thought about getting outside data? And so what we want to do is be able to document what system we're using out there. There's a couple of common salary surveys up here. One of them is by the Church Law and Tax Group. The other one is operated by the Church Network. Now, the problem with salary surveys is they work great for what I call small to middle-of-the-road churches. As churches get larger, you have a tendency to shoot yourselves in the foot. Because you stop responding to salary surveys. And the fact is we don't have enough larger churches responding to the salary surveys to create good data there. So then larger churches are then forced to use more expensive options such as salary experts that are going to charge a lot more than the salary survey is. Yes?
There is a mega church report that you can participate in. They're based out of Texas.
Yes, there is. There is a mega church report you can participate in and that you can then have access to based out of Texas, which is creating one of the most newest and best sources for mega church salary surveys, and that people are pretty happy with it. The normal surveys are having a hard time getting the larger churches to participate in them. Now, let me give you a caveat about salary experts. Compensation experts are not your attorney and your CPA. I have been doing this for 30 years. I am not a compensation expert. Can I tell you from my gut how much I think you ought to make or whether or not I think it's reasonable? I can, but I'm not an expert. I don't get to make that decision for you. And so I get really frustrated when I see one-page reports come from some CPA that is saying, yes, we find that your salary for your senior pastor is reasonable at between X and X. and they don't have the credentials or everything they need to support that. When you use outside salary experts, use real experts. This is what they should eat, live, and breathe for what they do. It's HR and compensation. Yes?
When you use the term leadership, how far down does that go?
So when I use the term leadership, how far down should that go? It depends on your church structure. I generally will do the upper level of senior pastors an absolute, and then it depends on how big the level is below that. That could be all your ministry heads, and I think it's important to do all your ministry heads, especially if they're making budget decisions and they're being given control and authority over a significant portion of the budget. The other issue might be how much their compensation packages are. The regulations in this section will go with everybody over $150,000. Our definition of key employee used for the 990, they consider that you would need to do this with. So I think it's somewhat a judgment call on each organization. Additionally, if you are compensating any of the relatives of those people, you have to do it for them because they're also disqualified persons. So I say do it for what I call a group of people, your movers, shakers, and decision makers. I tell people if they can rock and roll a significant part of your church and make decisions, they need to be in the group that we are using outside data to support their compensation for. Good question. Other factors when we talk about the limits for the position is, how many years of experience does somebody have? What are you requiring for it? What kind of degrees are you requiring? What type of experience? Are you looking at specialized knowledge up there? Obviously, your pastor that has pastored for 35 years and has a doctorate is going to garner a different range than someone holding a position that they just graduated from seminary and they've been doing this for 2 years. To me, they are. And so think about those factors. Looking at within your industry, within your area can be very helpful when we're in high dollar areas. You don't want to get somebody caught trying to compare you to West Texas. That is not going to be apples and oranges not to your favor at least, okay? And so you want to make sure you are considering geographic locations. One of the other areas I tell people to consider when looking at overall compensation planning is the overall financial health of the church and the overall compensation philosophy of the church. I'm not a big believer that the senior pastor should be making a ton of money in everybody else's poverty level. That is not a good message out there. But I do understand that some churches have a lower salary compensation philosophy, and some churches have a higher salary philosophy. But it should kind of be seen throughout the church and not just say in one or two positions. The next building block we want to talk to about is really near and dear to my heart for so many reasons these days, and that is determining the goals of your compensation package. And what we're talking, I bring this one to you. When we were sketching out the book, I said, I want to talk about work benefits and I want to talk about life benefits because I've been doing this for 30 years. Frank's been doing it for 40 years. Here's a phone call one of us gets at least once a month. Our pastor's retiring. He doesn't have a retirement plan. So we thought we'd just give him the house he's been living in. Or we thought we'd just continue to pay him $50,000 or $100,000 a year until he dies. Or we thought we would do a huge $500,000 farewell gift to him. And what has happened is now, because of a lack of planning and a lack of defining goals, financial goals for your employees, the church is in a situation that they don't know how to deal with, because they feel bad that their pastor is retiring and he has no retirement. So think about this ahead of time. Charge your compensation groups with thinking, if we only have so many dollars for compensation, what are our goals we want to meet? So Frank read this. What did you read the report? Well, I think you mentioned it earlier. 60% of ministers don't have retirement plans. 60%. 1 in 10 Americans are fully disabled before they retire. Do you offer or have disability insurance? Most pastors do not have adequate life insurance so that when something happens to them, the church then has to figure out, what do I do with a wife and 3 kids? How do we support them? Because you can't. And this is what I want to get at. You cannot be the stopgap when life happens. You have to plan for life to happen. This should be part of your goals. And so think about all the areas. Educational needs. This may be a goal of the church. We want everybody to be able to go get a college education, so we're going to make sure we provide for an educational assistance plan. Because that's important to us. Family needs. Millennials have children. I know they still live at home with their parents when they have them. No, I'm just kidding. My apologies to all the millennials in the room who are not living with your parents. I have both, okay? I have millennial living with his parents and a millennial not living with their parents. So, but yeah, we have childcare needs. Anybody priced daycare for infants?
$1,000 a month, easy.
Outrageous. So these are what are the needs? What are our goals? What do we want to try to help our employees when they come to work for us? What are they having to tackle? And we want to use our dollars as smart as we can use them. And sometimes that means we don't give that dollar to that employee in a paycheck. We give it to them another way. All right, I'm sorry, that's my soapbox these days. Building block number 5, after we've kind of figured out our goals, figure out what you can provide. How do we want to spend that dollar? What do we have that's easy? Do we operate a daycare already? So we can operate a dependent care plan by offering a discount over there? Are we part of a denomination that has retirement plans available easily? We don't have to pay to set them up. We can just send money and man, they work, and we can encourage everybody that way. What do we have that we need, that we can be accessible to us, and what do we still have to create to meet our goals? Figure out what's benefiting your employees now. That is everything that benefits your employees you have to deal with in the compensation realm, whether it's a dollar or it's a non-cash item. So are we providing housing? Are we providing autos? Are we providing insurance, educational programs? Let's see what else is up there. Childcare, retirement, tuition, love gifts, gift cards. Just start figuring it out. What's everything we're getting or giving? And how do we deal with that? Then what we have to look at is we want to select the benefits that fit our goals. And then when we select those benefits, we want to check the legal requirements. Oh, man, that's just the pits, isn't it? Somebody else might tell us how we have to do this. And that's because there are so many benefits out there that the difference between immediate taxation and deferred taxation or no taxation is in the legal requirements. And the one thing I can tell you your pastors don't understand and your employees don't understand is they don't understand when they talk to another pastor or employee at another church who says, we get this and we don't pay tax on it. They have no comprehension of how that works. So it may not be, maybe we decide to have a plan and maybe we don't have a plan. So after we figure out what we're going to offer, and we figure out how we're going to offer it, then we need to value it. We want to figure out what its value is. Because remember what we did just a few blocks back, where we figured out what the range of the position was worth? When we did that, we determined reasonable compensation for that position. Well, guess what? We can't pay unreasonable compensation. So we have to figure out if we value everything we add together, is it still within that range? So that includes everything. It's not just cash. When we figured out the range of payments, we didn't just look at cash. We got to look at everything. We got to make sure we document that it fits within that range. Guess what if it's too much? Something has to go. That's right. What if we still have room? Hey, we can add something else in. Or there's room for that bonus at the end of the year and we don't have to worry about it. Yes, ma'am.
Is
I would say there's no like right percentage. It's a little bit all over the map. The smaller the church, the bigger the percentage. The larger the church, the more it seems to settle in somewhere between 30 and 40% is staff cost.
Is that including benefits?
In some churches, it does catch that. You're saying 50, but I don't think it's 50 in the...
Last survey the ACT did said 50% was personnel costs.
Okay, so 50%, that would include your benefits. Yeah, to 50, 60. That's higher than the norm for compensation and benefits. But especially for larger churches, I don't usually see that high of a number. So it's really all over the map now, especially with the benefit plans that are available and how expensive they become. Step 7 becomes really super important because now I want you to write it down. I don't care what you think is private within your church. I walked in one time to a church. I was doing a compliance review. That's where Frank and I go in and we kind of play IRS or DOL agent. And we look at lots of documents and then try to figure out what you're doing that's not right. And I said, I need to look at all your personnel committee minutes. And they were like, oh, well, those meetings are so confidential that we don't write anything down. And I'm like going, that's not good. Because if you don't, as a corporate entity, if you don't document things in minutes, then they may not exist in the legal realm. So if you don't document compensation, the IRS says it was not designated. And if it's undesignated compensation, the one ruling we kind of skipped over a little bit was the CEO who took more compensation than was designated, and the IRS revoked the tax exempt status because of it. Because undesignated compensation can be deemed to be unreasonable compensation, even if it's reasonable. Unapproved compensation. And so you want to document why the compensation is reasonable. Now, once again, for your leadership team, these steps are super important. There's a little bit more fudging room on the extent of the documentation for rank and file, although you should have it in good HR policies and good business practices and good governance, but your leadership team is really critical. You want to document your outside sources that developed the range that you're paying within. You want to document when the decision was made and how the decision was made and who voted on it. You want to make sure it's clearly conveyed in the appropriate minutes or documentation, and then it makes it to the personnel file. And then very important, you want to make sure you very clearly document your housing allowance for all of your ministers. I ask that you document your housing allowance and your entire compensation package, and that means every benefit. If you want to say the senior pastor is also going to get health insurance through our group plan, that's fine. At least you've now documented it. Okay, you've approved being able to let him join the health plan. That's what you want to do. So you want to make sure each benefit is approved. And that's why it's important to get your list together. Make sure your housing allowance is approved and designated in advance in writing. You can change your housing allowance for a minister during the year on a prospective basis. They can't back it up, but they can change it going forward. Right? And then after that, we've got everything down on paper. We've decided who we're giving a percentage at the daycare. We've decided if we have a dependent care plan or we don't have a dependent care plan. Now we need to figure out what's taxable and what's not taxable. So the basis for U.S. tax law. Y'all ready for this? We have book after book written. But it all comes down to one core basis. Everything is taxable until you figure out a way it's not taxable. So when I look at a list of benefits, what's my presumption? When Pastor Joe down the street doesn't pay tax on it, does that mean it's taxable, not taxable? No, because Pastor Joe's probably not getting great tax advice. I'm just going to tell y'all that. How about the big mega church on the corner? They don't tax it. Does that mean it's not taxable? No, bigger does not mean right in the religious organizations.
And I'd like to make sure for pastors, the Social Security Medicare taxes are different from the income taxes.
Yes. And so for when we're looking at whether something is taxable or not, we are deciding, is it taxable for federal income tax purposes? And then for rank and file non-ministerial employees for IRS purposes, we're deciding, is it subject to Social Security, FICA, and Medicare withholding and matching? There's some discrepancy between whether or not a benefit is taxable for self-employment tax the minister pays and Social Security taxes an employee pays. But you're really concerned about on your ministers what goes into box 1. That's usually your federal taxable amount. And so sometimes if you have something that you're like going, gosh, this is taxable. I wish it wasn't taxable. Pastor Joe down the street doesn't pay tax on this. How do they do that? Then sometimes we can do it a little differently. It's like auto expenses. This is my classic example. If I pay an employee $500 a week for their automobile cost, because they're driving around for church business, and I just pay them $500 a week, is it taxable or not taxable?
Well,
It's taxable.
I want to reiterate for the minister stuff. If you withhold Social Security and Medicare taxes, the FICA and Medicare taxes, IRS takes that to mean that this is not a minister. We're not treating them as a minister. That makes the housing allowance taxable, and there's no way out of it. So the way you set this up is very important to keep it from taxable or non-taxable for your ministers. You've got to correctly prepare that W-2. So box 1 has something in it. Box 2 has nothing in it unless the minister chooses to have withholding. 3, 5,
3, 4, 5, and 6.
3, 4, 5, and 6 on ministers are always blank.
And so, so Frank's driving home the point is that if you have a minister for federal income tax purposes, you may never, ever, 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 ever withhold FICA and Medicare and match it. Never. No Social Security taxes come out of a minister's tax income. No SDI in California. So FICA and Medicare may not be withheld from a minister's pay and matched by the employer. May not, due to the definitions we have for what income is subject to that and what income is not. It is not an option the minister gets to make. They don't get to say, and this is what you're all looking at me like, see, as the employer, you only care about what you have to do on your W-2. The minister, by law, pays self-employment tax until or if he opts out of it. But the fact whether he opts out or not is his personal tax return issue. It never becomes an employee issue. 9 times out of 10, the minister will sit down with you and go, I didn't opt out of Social Security, so you have to withhold it and match it. No, that's not possible. He didn't opt out of Social Security, so he has to pay self-employment tax on his personal tax return. As the church, you don't care if they ever did the option out or not. And don't ask for a copy of it. Don't hand them an empty form. Don't tell them to opt out. Don't provide any tax advice in this area. Don't ordain a bunch of new ministers and hand them a form to opt out of Social Security. Okay, so ministers who come to Elaine and say, I'm thinking about opting out, get like a 45-minute lecture before I stop talking on what they have to think about. So the key you have to know as the employer is either you have to make sure you classify them correctly as a minister or not as a minister for federal tax law. Okay? And what Frank is saying is if the church messes up that classification and withholds FICA and Medicare from them and matches it, the IRS says, you just told me they're not a minister, they will not get a housing allowance. We will tax everything about them. All right. That's kind of our basic, 8 blocks. So that's just kind of a primer on compensation. There's obviously a lot more of that than in the book. But that I want you to know just to throw up some red flags in your process. So you can walk through your process and think, oh, yeah, we did this. Oh, we didn't do this. The most important thing I find is the step where we decide whether something's taxable or not. Because most churches and most employers are really good about getting to the W-2 what goes through the payroll system. You know, what goes through ADP or Paychecks or whatever system you're using. What they're not good about is looking at the other benefits and saying, oh, well, my auto allowance that I paid him $500 a week, that didn't make it to the payroll system. Or the youth minister, we let him send his kids. Nobody else got to do it, but we let him send his kids to the daycare for a 50% discount. Okay, you didn't let anybody else do it. You don't have a dependent care plan. That 50% discount is taxable. Or we think all our ministers need to send their kids to camp every year, so we pay for that. That's taxable. So it becomes important to look through and go through your benefits, because the biggest tax issues to your employees, mainly your ministers, which is what happens in all these cases, is the taxable items that do not end up on the W-2. And that's where your biggest risk is. And that's where they write big checks or you write a big check. Worse yet, you lose your tax exempt status as a church, or they end up with a tax evasion charge, which none of you want. And so it's really this is just kind of to bring highlights to you, and you got to throw it in here on top of everything else, to bring highlights to you, this is what the process should be. Are we walking through this process? All right, I guess that's it. Are we done?
We're done,
I think
Travis. Excuse me.
Let's hear it for Frank, Elaine.